repeat. Nevertheless, the entry made on the Nigerian Army Form 199A at the point of documentation after commissioning of an officer indicated that the former head of state obtained the West African School Certificate (WASC) in 1961 with credit in relevant subjects: English, language, geography, history, health science, Hausa, and a pass in English literature, end of quote. Curiosity and common sense will ask the question, if indeed the second respondent did not present his certificate to the Army when he was commissioned as an officer, where did the Army get the record in the Form 199A in his record that he had presented, that in Form 199A, which presented records of credits obtained by the second respondent in the WASC examination in 1961? The plausible and only reasonable inference is that the second respondent presented his WASC certificate upon joining the Army, from which the Army extracted the information in the Form 199A to show that the second respondent indeed has secured education up to school certificate level and in fact possessed the WASC certificate in 1961. Section 167 of the Evidence Act 2011 says, the court may presume the existence of any fact which it deems likely to have happened, regard being had to common cause of natural events, human conduct, and public or private witness in their relationship to the facts of the particular case. It would be incredible and even repugnant to common sense and justice to hold, on the face of the evidence produced by the petitioners themselves in Exhibit P24, that the second respondent does not possess qualification to contest the office of the President of the Federal Republic of Nigeria as prescribed by Section 131 and defined in Section 318 of the Constitution, or that he has submitted an affidavit to the first respondent containing false information, fundamental in nature or in aid of his qualification. If the Army admits and confesses in the above statement that it has a record which indicates that the second respondent has obtained a WASC certificate in 1961 and even stated the grades he scored in particular subjects, where then lies the falsity of the information deposed to and submitted to first respondent in support of his qualification for the contest, for the election of 23rd February 2019. The petitioners also tendered the CV of the second respondent, showing his educational background, military service, public service, becoming ultimately the head of state and commander-in-chief of Nigeria, commander-in-chief of the Armed Forces of Nigeria from December 1983 to 85. All of this were confirmed by Brigadier General Olajide Olaleye, who said the second respondent rose steadily in his career to become the head of state of Nigeria. In my view, the CV contains impressive credentials to enable the second respondent contest and hold the office of the President of the Federal Republic of Nigeria, even if it could be said that he has only a primary school certificate, which is not the case here. The second respondent has more than secondary school certificate, having attended courses, evidence of which have been attached to his Form CF001. There is no doubt that the second respondent is not only qualified, but is also eminently qualified to contest the February 23rd presidential election from the evidence presented by the petitioners themselves, as stated out above. The petitioners cannot run away from the facts that are favorable to the second respondent, particularly in exhibits P1 and P24 tendered by them. The fact that the second respondent did not attach his certificates to the CV or to Form CF001 cannot lead to the conclusion that he did not obtain the certificates or that he is not educated up to certificate level or is equivalent as required by the Constitution. Since the documents in Exhibit 24 and 131 were tendered to advance the petitioner's case, this court is entitled to utilize them and validate them and in an advantage position to draw the inference and reasonable conclusion which can be found in such exhibits. A close scrutiny or a perusal of the petitioner's averment in Section 388 to 405 discloses that the case of the petitioners is that the second respondent was not qualified to contest the election because he does not possess the educational qualification to contest the election. The paragraph 398 specifically accuses the second respondent of submitting the Form CF001, wherein he filed in paragraph C, column 2, page 3, under secondary school wrote WASC, thereby falsely claiming the qualification which he submitted to INEC, whereas there was no qualification known as INEC as WASC at then. That is the petitioner's case. However, by their own evidence and by their own case, they have shown that the second respondent has obtained the said qualification and that WASC was in existence at the time the petitioner joined the Army and submitted his credential to them for enlistment. The second aspect is that the petitioner swore to an affidavit containing false information. Paragraphs 397 and 404 pleaded that the schools the second respondent claimed to have attended were not at the material time existent. However, there is no pleading in the petition to the effect that the second respondent's failure to attach his certificate to Form CF001 amounts to lack of qualification to contest the election. In other words, the issue of failure to attach certificate has been overflogged throughout the length and breadth of the petitioner's address in reply to the final addresses by the respondent. No issue was joined on non-production of certificates or failure to attach them as an infraction of Section 131, 137, and 138 of the Constitution of the Federal Republic of Nigeria as amended. Parties are, of course, bound by the pleadings, and any evidence or witnesses or addresses of counsel which is contrary to the case pleaded in a party goes to no issue. And the court will, in the circumstance, discountenance such evidence. A party will not be allowed under any guise to deviate from his pleadings. All the submissions about failure to produce certificates or attach same to Form CF001 in this petition are hereby discountenanced. But even if it can be said that the submissions made are in tandem with the petitioner's pleading on issues 1 and 2, the fact remains that none of the facts pleaded were proved or established as required by law. It must be stated that the evidence of RW1, so much relied upon with elation, has no relevance to, or weight at all to the second respondents, that the second respondent never deposed to an affidavit stating that he submitted his certificate to the Army when he enlisted in the Nigerian military school, Kaduna, in 1962. What the second respondent deposed to was that in November 2014, stating that his educational qualifications are with the Army, not at the point of enlistment. If Exhibit 24 is anything to go by, it clearly, like I said before, punctured the case of the petitioners because the Nigerian Army, through Brigadier General Olajide Laleye, has stated that the record shows that the second respondent was a Form 6 student at the Provisional Secondary School Katsina as at the 18th of October 1961, when he applied to join the army. And it was on the recommendation of his principal, who assured that the second respondent would pass his examination in Maths, English, and 3 other subjects, that he was enlisted into the army, and he eventually passed out thereafter. In effect, there could be no certificate deposited with the Nigerian board when the second respondent. In effect, there must have been a certificate deposited with the Nigerian army when he joined the military school and was enlisted in the army, as was clearly stated by Brigadier General Laleye. On the claim that the school attended were non-existent, the petitioners have been proved wrong by Exhibit 1 and Exhibit PT2 tendered by them from the bar. There is no other scintilla of evidence to establish or prove that the school entered into Form CF001 were non-existent at the time the said form was filed. The overwhelming evidence of RW1, 2, and 4 positively show that the schools actually existed and the second respondent attended them. Exhibit P30, tendered from the bar as archival document, was only dumped on this court without any evidence to breathe life into it. PW62 confessed under cross-examination that the facts contained in the witness statement on oath was gathered from information passed on to him from others. In any event, he gave no evidence concerning the exhibit because the facts stated therein contained are not to his personal knowledge or from his personal knowledge. In effect, exhibit P30 are also of no probative value. The allegation that the school were not in existence and there was no certificate have now been debunked by the petitioners themselves, and so they have failed to discharge the honors placed on them to prove the allegation of non-qualification or submission of an information which contains an information that is false, which is fundamental in aid to the second respondent's qualification to contest the election. In the case of Maku and Al-Makura, decided in 2016, citation of which is set out, MD Muhammad JSC has said, lastly, the essence of front-loading statement of witnesses is to facilitate speedy disposal of election petition and does not justify dumping of exhibits, and urging the tribunal and the court to proceed in a manner that opens them to unnecessary and avoidable suspicion of bias. All facts that entitle the party to the court's indulgence must be demonstrated in the open court to ensure that in arriving at the decision on the matter, the court is detached and neutral, as anyone could easily see. The examination of exhibits outside the court and behind the litigant certainly stands in the way of these necessary and laudable traits. See Obasi Brothers Limited, MBA Securities, Supra, and Oilo and Akibu, 1982, 7SC, 60 and 62, and Ucha and Elechi Supra, end of quote. I also refer to the case of Ladoja and Ajimobi, which was decided also in 2016. On the failure of the first respondent to call or produce evidence, the petitioners have contended that the facts pleaded by them and by the first respondent in paragraph 98(1) of the first respondent's reply to the petition, to the effect that it was satisfied with the educational qualification presented by the second respondent, was not proved or established by the first respondent for failure to call evidence. They submitted that that inasmuch as no one was called to tell the court on the alleged admissibility, acceptability on the second respondent's qualification, the learned senior counsel to the petitioner therefore submitted that paragraph 98, sub Roman 2 of the first respondent's pleading is abandoned. In his reply, the learned senior counsel submitted that there was a petition, that where a petitioner has not made out or proved his case in the petition during examination in chief, the respondent will not be called upon or required to offer evidence in defense, and that where a party has extracted evidence favorable to his case and the petitioner fails to discharge the burden on him, the respondent is not bound to call evidence. He relied on some cases, among which is Akambi and Alao, citations of which are set out. Learned senior counsel also submitted the petitioner's claim is declaratory in nature, and there is the heavy burden on them to prove it and not rely on either failure or default in defense by the respondents. In that case, the submission of the first respondent's learned counsel represents the law, and in that, the petitioner who alleges that the second respondent does not possess educational qualification to contest the election to the office of President of Nigeria, and they pray for declaratory relief. This much the petitioners considered in paragraph 1.01 of their final address in response to the first respondent's final address. That being the case, the onus rests squarely on them to prove the assertion that the second respondent is not educationally qualified to contest the election, or that he submitted the affidavit containing false information of a fundamental nature in aid of his qualification for the said election. This, like I've mentioned before, the petitioners have not been able to do. They cannot therefore rely on refusal or failure of the first respondent to call evidence to show how it was satisfied with the second respondent's educational qualification. I made reference to some cases. What is more, the petitioner pleaded that the second respondent, who was sponsored by the third respondent, and that he contested the election. The petitioner also pleaded that he submitted this form along with some other documents which they are not challenging. This is because the second respondent went through the procedure in Section 31 of the Electoral Act and was cleared to contest the election that enables the petitioner to challenge his qualification as pleaded by them in paragraph 388 to 405 of the petition. The presumption is that the first respondent was duly cleared him to contest the election, and we made reference to some cases. The petitioners also tendered all documents compiled and submitted in Form CF-001 as Exhibit 1. The submission that INEC is deemed to have abandoned its pleadings cannot therefore hold sway on whether exhibits R19 and R21 are covered by Section 83(3) of the Evidence Act. The petitioners have submitted that the said exhibits are inadmissible because they were made by a party interested when proceedings were anticipated, and in this case, after the petition had been filed and hearing commenced. In response, the learned senior counsel to the respondent dealt with the issue in paragraph 423 and 425 of the reply to the petitioner's final written address. The learned senior counsel to the second respondent argues that the petitioner misconstrued Section 83(3) of the Evidence Act in that exhibit R19 and 21 were actually made or produced by the West African Examination Council, WAEC, and the University of Cambridge, respectively. He also said that the documents were only obtained and not made by the second respondent, who is said to be the interested party here. The petitioners have not accused the University of Cambridge or WAEC for being persons interested, and on the meaning and scope of Section 83(3) of the Evidence Act, the learned senior counsel referred to, among other cases, Kelechi and Wale, citations of which are set out. I am of the view that the second respondent is not the maker of exhibit R19 and 21, though he may be interested in them. It has not been shown or proved that the West African Examination Council and the University of Cambridge are persons or people interested in these proceedings. Whether there is variation in names of the second respondent on Exhibit R19 and 21 as to whether it is Mohammed with O or Mohammed with U, the petitioner stated that the document cannot be said to belong to the second respondent because no facts were pleaded to reconcile the names. However, the learned counsel for the second respondent submitted that the supposed variation will not detract from the fact that the name is and could be borne by one and the same person. The learned senior counsel relied on the case of A.D. and Fayoshi, citation of which is set out. He also relied on the evidence of RW5, who gave explanation on the names and stated they are the same. He drew an analogy from the name of lead counsel for the petitioners, whose names are Dr. Livinus Ifeanyi Uzoku SAN, signing off processes as Dr. Livy Uzoku SAN. The variation in name of the second respondent on Exhibit R19 and 21 is non sequitur, since both of them refer to and were issued in respect of the same person who bears the names set out therein. Whether Mohammed with an O, or Mohammed with a U, or Muhammadu, the names refer to one and the same person in respect of who the exhibits were issued, particularly since the name Buhari on the exhibit indisputably refers to and belongs to the second respondent and no other person. After all, a name is defined at page 1048 of the 8th edition of the Black's Law Dictionary to mean, I quote, a word or phrase identifying or designating a person or thing and distinguishing that person or other thing from others. From the totality of the evidence before the court, the names Mohammed Buhari with the U, Mohammed Buhari with an O, contained in Exhibit R19 and 21, all refer to, identify, and belong to the second respondent in respect of which they were issued. I am of the view that upon all the pieces of evidence given, both oral and documentary, on the issue of qualification or on the issue of allegation of affidavit, of submission of an affidavit containing false information tendered or proffered in this case against the second respondent, there is no doubt that Exhibit R19 and 21 relate to the second respondent. I have no doubt in my mind again that the petitioners have not proved or established that the second respondent does not possess the educational qualification to contest the election of the office of the President of the Federal Republic of Nigeria as prescribed and stipulated under sections 131, 137, and 138, 1A, B, C, Roman 1, 2, 3, and paragraph D of the Constitution of the Federal Republic of Nigeria as amended. I'm also of the firm view that the petitioners have failed to prove or show that the second respondent had submitted to the first respondent an affidavit containing false information of a fundamental nature in aid of his qualification for the election as prescribed by Section 35(1) of the Evidence Act 2011 and settled by the decision of the Apex Court. Before leaving this issue, learned senior counsel for the third respondent had argued what he termed subsidiary issue under the subhead non-qualification of the first respondent in his treatment of the petitioner's issues 1 and 2. All that needs to be said on the issue, all that needs to be said on the subsidiary issue and the arguments thereon go to no issue, since the paragraphs of the third respondent reply to the petition on the first petitioner's qualification to contest the election have been struck out for being incompetent by the ruling of the court on the petitioner's motion of 13th of May 2019 just delivered. As a consequence, after a review, a critical examination and evaluation of all the evidence adduced in this petition, particularly as it relates to issues 1 and 2 of the petitioners, I come to the conclusion that issues 1 and 2 of the petitioners are hereby resolved against them. I now go on to deal with issue 3, which was also canvassed by the learned senior counsel for the parties. And after a consideration of all the submissions on issue 3, I resolved it as follows. Issue 3 deals with ground 15A of the petitioner's petition. And once again, it reads, the petitioner states that the grounds upon which this petition is based are as follows. A, the second respondent was not duly elected by majority of lawful votes cast at the election, end of quote. The ground is predicated on section 138(1)(c) of the Electoral Act as amended, which provides for it as a ground for presentation of a petition. The law is that where an election conducted by the National Electoral Commission, including the election in question, a return is made and a candidate is declared as elected, as in this case, then section 68(c) of the Electoral Act as amended in 2010 as amended, makes the declaration and the return made by the designated electoral body final, subject only to review by the court or tribunal as and by way of an election petition as in the present petition. Section 147, 148, 168, and 167, 168(1) of the Evidence Act 2019 presume the result of the presidential election declared by the first respondent on the 27th of February 2019 as correct, authentic, and true until proof otherwise. Because it is a rebuttable presumption, the burden is on the petitioner who claim that the results are not true, they are not correct or authentic. This position of the law has been considered in many cases, a legion of them. And I just refer to the locus classicus, Omoborio and Ajasi, citation of which is set out, where Bello JSC then, and later CJN, and also of blessed memory, stated, now, as I stated in Wobodo and Ono, Supra, there is in law a rebuttable presumption that the election result of any election declared by a returning officer is correct and authentic by virtue of section 115, 148(c), and 149(1) of the Evidence Act, and the burden is on the person who denies the correctness and authenticity of the return to rebut the presumption. Where such denial is again, polling booths at the base of the pyramid, which forms the electoral process under the provisions of the Electoral Act 1982. The booths are the roots which nourish the whole electoral process. Where a petitioner challenges the correctness of the return of an election declared by the returning officer, then except in arithmetic errors in collation, the petitioner must lead evidence which would directly or indirectly establish the votes scored by him and his opponent at the polling booth. Similarly, in Buhari and INEC, decided in 2008, citation of which is also set out, Nikitobi, of blessed memory, has said this, and I quote him, election results are presumed by law to be correct until the contrary is proved. It is, however, a rebuttable presumption. In other words, there is a rebuttable presumption that the result of any election declared by a returning officer is correct and authentic, and the burden is on the person who denies the correctness and authenticity of the return to rebut the presumption. See Omoborio and Ajasi, 1984, 1 SCNR 04, Jalingo and Nyame, 1992, 3 NWLR, part 231 at page 538. Finebone and Brown, 1999, 4 NWLR, part 600 at page 613. Hashidu and Goji, 2003, 15 NWLR, part 843, 352, and Buhari and Obasanjo, 2005, 13 NWLR, part 941 at page 1, end of quote. The petitioners pleaded in paragraph 16, 17, and 18 of their petition as follows, and I set them out. And in order to prove the pleadings and the assertions above, the petitioners are by law under the legal obligation to call oral or documentary evidence through witnesses who are eyewitnesses, who can give cogent and direct evidence and demonstrate before the court that there is any misapplication of votes scored by the parties at the said election. In Atiku, Raja Abubakar Atiku GCON and Umaru Musa Yar'Adua decided in 2008, which I have referred to in one of the rulings. Nikki Toby again, of blessed memory, has said that a petitioner who contests the legality or lawfulness of votes cast at an election and the subsequent result must tender in evidence all the necessary documents by way of forms and other documents used at the election. He should not stop there. He must call witnesses to testify to the illegality or unlawfulness. Substantially, he must call witnesses to testify that the illegality or unlawfulness substantially affected the result of the election. The documents are among those in which the results of the votes are recorded. The witnesses are those who saw it all on the day of election, not those who picked the evidence from eyewitnesses. No, there must be eyewitnesses too. Both forms and witnesses are vital for contesting the legality or lawfulness of votes and the subsequent result of an election. One cannot be a substitute for the other. It is not enough for the petitioner to tender only documents. It is incumbent on him to lead evidence in respect of the wrongdoings or irregularities, both in the conduct of the election and recording of the votes. Wrongdoings and irregularities which affected substantially the result of the election, end of quote. I also made reference to some other cases on this position of the law. And the petitioner, being conscious of the onus of proof heavily placed on them by the law, have pleaded in paragraph 19 of the petition that the petitioner shall lead oral and documentary evidence at the trial to show that the results of the election as announced by the first respondent, and especially the votes credited to the second respondent, do not represent the lawful votes cast. Lawful votes were deducted from the first petitioner's scores by the first respondent in order to return the second respondent, end of quote. The petitioners have tendered from the bar from EC8As, EC8Bs, EC8Cs, EC8E, and other electoral forms or documents, particularly in respect of 13 states, including FCT Abuja, which they call the focal states. They also call, like I said before, 62 witnesses to prove the petition. The order in which the said witness testified and the states and the areas of their testimony have well been captured in the addresses of the parties. I will just reproduce some of them, and I did. The main contention or issue under this issue 3 is that the petitioners, the first respondent, has stoutly denied the existence of a server referred to and pleaded by the petitioners in their petition. The first respondent also vehemently contended that the result of the presidential election was never transmitted electronically via the smart card readers into any server belonging to INEC, and that there's no provision in the Electoral Act 2010 as amended that prescribes transmission of election results from the polling booths, polling units, polling voting points, ward level, LGA level, state, or national level. The same position was also taken by the second and third respondent. However, the Learned Senior Counsel for the petitioners insisted that by the amendment of the Electoral Act in 2015, the Act number 15, which came into effect on the 26th of March 2015, Section 9 thereof amended Section 52 of the Principal Act by inserting the following new section. That's subsection 2, which provides thus: voting at an election under this Act shall be in accordance with the procedure determined by the Independent National Electoral Commission, end of quote. The Learned Silk said, to the Learned Silk for the petitioners, INEC was empowered by this provision to transmit result of election from polling units via smart card readers direct to INEC server by presiding officers or assistant presiding officers. He also submitted that it was as a result of the amendment that INEC made or issued the Manual on Election Technologies, Use, Troubleshooting and Maintenance 2019, which is put in evidence as Exhibit P33, Regulations and Guidelines for Conduct of Elections, Exhibit P27, and 3, Manual for Election Official 2019, which was put in evidence as Exhibit P28. Learned Senior Counsel for the petitioners strongly submitted that the combination of the above exhibits, P27, P28, and P33, constitute the authority and power of INEC under Section 52(2) of the Electoral Act as amended to transmit result of the presidential election from the polling units electronically into INEC server, and that it was the result uploaded into that server through the process he mentioned that gave the first petitioner an edge over the second respondent, relying on the pieces of evidence by PW3, PW4, PW16, PW17, PW36, PW59, and PW60. The issue here is, can it really be said that Section 52(2) of the Electoral Act as amended actually empowered or authorized INEC to electronically transmit the result of the election from all the polling booths across the nation via a smart card reader? The law is settled that if the words of the statute are unambiguous, they must be followed and interpreted in such a manner that would best bring out the manifest intention of the lawmaker. The bottom line is that it is the duty of the court to interpret provisions of a statute in order to ascertain the intention of the legislator and give effect to it. If there is any lacuna or imperfection in the law or statute, it is not the function of the court has no power to amend the law. It is in the domain of the legislature. And I refer to some cases on this. I have read the entire provisions of Section 52 of the Electoral Act as amended, and which I also set out. And I say that in the exercise of the power vested in it by the provision in subsection 2 above, the first respondent, INEC, made and issued Exhibit P27, which is Regulation and Guidelines for the Conduct of Elections, and Exhibit P28, the Manual for Election Officials 2019, for the purpose of the procedure to be adopted and used for the conduct of the 2019 elections. In paragraph 8A of Exhibit P27, dealing with accreditation and voting procedure at election. It is provided as follows, and I quote, "Voting shall be in accordance with the continuous accreditation and voting system, CAVS, procedures as specified in these regulations and guidelines, the election manual, and any other guide issued by the Commission," end of quote. Then in paragraph 10A, it is provided that, and I quote, "In accordance with section 49(2) of the Electoral Act, a person intending to vote shall be verified to be the same person on the register of voters by use of the smart card reader, SCR, in the manner prescribed in these regulations and guidelines," end of quote. Elaborate procedure was then set out in paragraph 10C to F for accreditation and in paragraph 11A for voting at an election. At the end of voting, or at the close of voting, paragraph 22A, B, and C of Exhibit 27 provides the procedure for the collation, counting, recording, announcement/declaration, and transmission of the result of the election from the polling units or voting points to the registration area or ward level. These provisions are thus, and I quote them, 22A, at the close of voting, the presiding officer shall, A, cancel all the unused ballot papers by crossing, 2, sort out the ballot papers by party, and thereafter loudly count the votes scored by each political party in the presence of the polling agents and observers. 3, allow recounts of votes on demand by a polling agent, provided that such a recount shall only be allowed once. 4, cross-check the scores. 5, enter the scores of the candidates in both figures and words in the appropriate forms, EC8A/EC8A VP in bracket series. And 6, fill the form EC60E and paste it conspicuously. Pasting the form EC60E is mandatory, and failure to do so may amount to dereliction of duty. B, where voting points have been created, the APO1 shall, Roman 1, enter the result on form EC8A, VP in bracket, and 2, submit to the presiding officer, who shall consolidate the result using form EC8A and attach the form EC8A, VP in bracket to form EC8A. C, the presiding officer shall then sign, date, and stamp the appropriate forms EC8A forms. 2, announce loudly the votes scored by each political party. Roman 3, request the candidate or their polling agents where available at the polling unit to countersign. And then 4, refusal of any candidate or polling agent to countersign the appropriate form EC8A series shall not invalidate the result of the polling unit. Keep the originals of the form EC8 series and the first pink copies for the Commission. 6, give to the polling agents and police a duplicate copy of each of the completed forms. 7, post the completed publication result poster form EC60E at the polling unit. Complete the form EC40H1 for PWD information and statistics. Complete the PWD information boxes in PU booklet. Transmit the result as prescribed in the Electoral Act. Take the card reader and the original copy of each of the forms in temper evidence envelope to the registration area ward collation officer in the company of security agents. And lastly, 12, the polling agent may accompany the presiding officer to the RA/Ward Collation Center. Then paragraph 27, Roman 7, paragraph 28B, Roman 1 to 14, paragraph 30, paragraph 31, and paragraph 32 of XBP 27 provide for the procedure for the collation and transmission of election results from the ward to the national level in respect of the presidential election. The procedure elaborately set out in the above paragraphs of XBP 27 are repeated in Chapter 3, paragraph 3.1a, Roman 7, paragraph B, C, D, and E of XBP 28. At page 68 of XBP 28, the title, quote, Election Collation Flow Charts, Presidential, end of quote, was provided, clearly demonstrating the procedure provided for in the aforementioned paragraphs. As can be clearly seen, it is undeniable that the procedure for collation and transmission of election results in the above paragraphs of XBP 27 and P28 is manual by election officials at different and all levels or stages of an election, from the polling units, voting points, which are the foundation for every election conducted under the Electoral Act, to the final stage for the purpose, for our own purpose here, the national level. There's no provision in either XBP 27 or P28 for transmission of election result electronically, either by the use of smart card reader or other means at any level of an election. In addition, there's no provision in the amended Electoral Act authorizing or empowering the first respondent or any of its officers, including presiding officers 1, 2, and 3, mentioned in XBP 27 and 28, the regulations the regulation and guidelines for conduct of election, and the manual for election official 2018, which allow transmission of election result electronically to any server through the use or by use of a smart card reader. There's also nothing, even in XBP 27 and 28, empowering or authorizing election officials of the first respondent to use the smart card reader for electronic collation and transmission of the results. The reliance placed on XBP 33, Manual on Election Technologies, pages 15 to 32 thereof, is misplaced because there's no evidence before the court that the said XBP 33 was deployed for use in the 2019 elections. XBP 85, which was a video tendered through PW40, points to the contrary. The first respondent's chairman had, in the said exhibit, informed the public that due to logistics problem, transmission of election results via electronic transmission was not feasible or attainable. XBP 27 and P28 show that the results of the election were to be manually collated, entered into various appropriate forms by the election officials manually, and results announced publicly at every stage of the electoral process. The evidence of PW62, the star witness for the petitioners, veers and supports the position and the fact that there was no electronic voting and results were not transmitted electronically, even during the collation and announcement of the presidential election at the national level by the first respondent's chairman. The evidence of PW2, PW4, PW16, PW17, and PW36, which are invariably in respect of only 5 polling units, did not establish that there was electronic transmission of results of the election in the entire polling booths and polling points, voting points in the country by the use of smart card reader. These witnesses, in addition, have said that under cross-examination, informed the court that they did not know the identity or the particulars of the alleged INEC server into which they allegedly transmitted results of the election. Some of them even gave evidence that INEC gave them the code to transmit the result electronically. But when asked the PIN number of the code, some of them stated that they could not disclose the code, while others said they could not remember. The pieces of evidence given by the said 5 witnesses does not have any bearing or impact on the proof required of the petitioners. It is like a drop in an ocean. Their evidence, either alone or together, have failed to establish the claim that of the petitioners on the issue of electronic transmission of results. In effect, the petitioners have not proved this aspect of their case. I'm not unmindful of the submission of the Learned Senior Counsel to the petitioners, who, while relying on Section 153 of the Electoral Act as amended, stated in the written address, which I set out, and I'll read, paragraph 4.24. It is pursuant to the above provision that the first respondent prescribe elaborate procedures for electronic collation and electronic transmission of results for the 2019 election. It is clear that the first respondent, under the heading Accreditation and Voting Procedure at Election, in its 2019 election guidelines P27, made elaborate provisions on use of voters' register and card readers in the accreditation of voters and voting procedure. See paragraphs 8, 10, 11, 12, and 13 of Exhibit P27. It is noteworthy that the scope covered by the above procedure is wider than the guidelines for the 2015 general elections. See also paragraph 23 to 28 of the Manual for Election Official 2019, Exhibit P28. Like I said before, I have carefully examined and re-examined Exhibit P27, and there is nothing again contained on electronic collation and electronic transmission of results for the 2019 general election, particularly in the presidential election conducted on the 23rd of February 2019. It is also the contention of the petitioners that the scope of exhibit covered by Exhibit P20 is wider in scope than the guidelines of 2015 general election. The Exhibit P27 does not, with respect, support the submission of the Learned Senior Counsel. Contrary to that submission, and contrary to submission on Section 52.2 of the Electoral Act, that it now gives backing to the first respondent to transmit results of election electronically via the smart card reader. There is no such statutory backing as has been demonstrated above before now. The position on the use of smart card reader in election has not changed since 2015 for the simple reason that the court and the electoral law outlawed the use of electronic voting. It is stipulated to have been prohibited. However, even if there's no electronic voting, there's no provision of the Electoral Act, as I mentioned before, which provides for the collation and transmission of election results at all levels of an election in Nigeria. The controversies engendered and generated by the use or non-use of the smart card reader in the 2015 election, and whether the card reader report can be used to determine the actual votes or results in an election, including the presidential election, has been considered by the Supreme Court in a number of cases. And the Supreme Court has settled the law on the position on the position of the use of the card reader in an election, and he interpreted Section 52, 1B of the Electoral Act 2010 as amended, which provides for the use of electronic voting machine for the time being prohibited in a number of cases, among which is Yensam and Peterside, where Kekerekun has said, it will not therefore be out of place to say that both lower courts place considerable reliance on the testimony of PW 49 and the card reader report, Exhibit A9, and Exhibit A301, A30, and A31, in reaching the conclusion that the first and second respondent had successfully proved alleged discrepancy between the number of voters accredited in Exhibit A9 and those reflected in Exhibit A10 from EC8E series. This court, in a number of recent decisions, has commended the introduction of the card reader in the 2015 election by INEC. The court noted, however, that its function is solely to authenticate the owner of a voter's card and to prevent multi-voting by a voter, and cannot replace the voter's register or statement of result in the appropriate forms. See Shinkafi and Yari Supra, Okereke and Umahi, unreported, SC 1004/2015, delivered on the 5th of February 2015, at pages 31 to 34, end of quote. And it's at pages 525A to H, the Lordship continued and said, as I stated earlier in this judgment, that INEC is to be commended for the innovation of the card reader machine to bolster transparency and accuracy for the accreditation process and to maintain the democratic norm of one man, one vote by preventing multi-voting by a voter. Nonetheless, Section 41, Sub 1 and 2 of the Electoral Act 2010, as amended, which provided for manual accreditation of voters, is extant and remains a vital part of our electoral law. The section provides thus: any person intending to vote with his voter's card shall present himself to a presiding officer at the polling unit in the constituency in which his name is registered and with his voter's card. 2, the presiding officer shall, on being satisfied that the name of the person is on the register of voters, issue him with a ballot paper and indicate on the register that the person has voted. In the recent decision of this court in Shinkafi and Yari, 2016, 7 NWLR 1511, part 1511, page 340, Okoro JSC stated thus: my understanding of the function of the card reader machine is to authenticate the owner of a voter's card and to prevent multi-voting by a voter. I'm not aware that the card reader machine has replaced the voter's register or has taken the place of statement of results in appropriate forms, end of quote. Again, Her Lordship continued, Mwezi JSC, Kereke and Umahi and others, unreported, SC 1004/2015, delivered on the 5th of February 2016, reiterated the position, thus at page 33 to 34. And he did. Indeed, since the guidelines and manual supra, which authorized the use and deployment of the electronic card reader machine, were made in exercise of the powers conferred by the Electoral Act, the said card reader cannot, logically, depose or dethrone the voters' register, whose juridical roots are firmly embedded or entrenched in self-same Electoral Act from which the voters' register directly derives its sustenance and currency. Thus, any attempt to invest it, the card reader machine, with such overriding preeminence and superiority over the voters' register is like converting an auxiliary procedure into a dominant procedure of proof that is proof of accreditation. In order to prove non-accreditation or / overvoting, the first respondents were bound to rely on the voters' register in all the affected local governments. The voter registers tendered were in respect of only 11 out of the 23 local governments. They were tendered from the bar as Exhibit A 207 to 281. No attempt was made to link them with Exhibit A9. It is also noteworthy that Forms EC8A were tendered in respect of only 15 out of the 23 local government areas. An attempt was made to confront some of the defense witnesses with the Forms EC8A to show that the number of votes credited, motor of voter credited, stated therein was in conflict with the number of accredited voters as per Exhibit A9. In any event, as rightly submitted by the Learning Council for the appellant, the tendering of Exhibit A9, A10, A12, A31, A32, A270, A271 to A281, A282 to A380, 300, A301, A303 to A307, B30, and B1 from the bar, without their makers being called, amounted to documentary hearsay, and the tribunal and the lower court were wrong in placing reliance on them. I am of the view, and I do hold, that the tribunal and the lower court were unduly swayed by the INEC directives on the use of the smart card reader. As held by this court, the INEC directives, guidelines, and manual cannot be elevated above the provisions of the Electoral Act so as to eliminate manual accreditation of voters in an election. This will remain so until INEC takes steps to have the necessary amendment made to bring the use of the card reader within the ambit of the substantive Electoral Act. I also refer to some other cases and pronouncement by the Supreme Court. Now, PW 59 was specifically called to establish the existence of an INEC server and to show that the result imputed into the alleged server through the smart card reader, the petitioners proved all the irregularities contained in all the 35 states of the Federation and FCT, except Rivers State, as pleaded in paragraph 16 to 106 of the petition. Reliance was placed on exhibits 87, P87 to P88, and P89. The petitioners also relied on what they described as analysis of votes. The results obtained as reflected in the certified true copies of Form EC8A, EC8B, and EC8E from 11 focal states, namely Kaduna, Katsina, Kebbi, Kano, Borno, Gombe, Jigawa, Niger, Yobe, and Zamfara states are pleaded in paragraph 113 to 363 of the petition. And they called PW6, who is referred to as a statistician and an expert, whose reports were admitted in evidence as Exhibit P90 A to K in respect of the 11 aforesaid states. PW 59 testified on the 19th of July when he adopted his statement on oath, and his evidence revealed that his report is based on a website whose owner he did not know. The website is www.factsdon'tlie.com, factsdon'tlieng.com, according to PW 59. And that the author of the website relied upon by him had claimed to be a former INEC staff. The website, according to PW 59 was created on the 12th of March, 2019, about 2 weeks after the result of the presidential election was announced. On page 6 of Exhibit A, attached to his witness statement of oath, PW 59 said he copied into page 6 annex diagram for training manual, and concluded on page 6 of Exhibit 8, attached to his written statement on oath, as follows. I will quote him. Whistleblowers Data Analysis Fact Don't Lie website, www.factsdon'tlieng.com. The website was created on the 12th of March 2019. A look at the website will show that apart from the information on INEC records, nothing else appeared there. It has no other basic information or navigation features as to what a regular website ought to contain as a contact, about, etc. The author of the content of the website revealing the information on INEC server claimed to be an INEC staff. He remained anonymous and hence Christian whistleblower. In paragraph 18 and 19 of his witness statement of oath, he concluded as follows: bearing a simplified and common understanding of the server and quotation and a computer, a device or a program that is dedicated. I'll take that again. A, bearing a simplified and common understanding of a server or a computer is a device or a program that is dedicated to managing networks, resources, such as storage, communication, security, centralized applications, and database management system, and acknowledging the INEC guidelines which outline a transparent and integrated electronic process of voters' accreditation, vote collation, and transmission. Indeed, there existed a robust system of servers whose extensive use in the presidential election is undeniable. B, the analysis of data held at the whistleblower website using standard professional data analysis tools and techniques authoritatively demonstrates accuracy and precision, legitimacy and validity, reliability and consistency, timeliness and relevance, completeness and comprehensiveness, granularity and uniqueness of the database, of the data whose base can be nothing but INEC servers. C, an expertise, corroboration, and correlation of the technical processes, data, and description of whistleblowers' data hearing and the INEC setup is an explicit and implicit demonstration that the server from whose data the whistleblower was drawn is INEC tallying server. 19, that a report in my findings are attached and marked as Exhibit 8. Its evidence is that it is the whistleblower's data analysis, Facts Don't Lie website, www.factsdon'tlieng.com, that his report is based on. He variously referred to the owner of the website as a whistleblower, as anonymous, or the author of the content of the website claimed to be an INEC staff. PW 59, as could be seen in his evidence, did not rely on any data gotten by him from INEC server. He stated that the server he relied upon for his report as an expert was an anonymous website, which to me is doubtful, unreliable on any account for any information that would be relied on by an expert who is truly an expert. PW 59 gave his evidence and report, and the report he authored. Whatever results he claimed to have gotten, according to him, came from the server belonging to a whistleblower and not INEC. When asked under cross-examination the source of the results he claimed were found in the anonymous website, PW59 said the author of the content of the website may be an INEC staff, but that the anonymous author of the content of the website got the information or the result from INEC servers, which he said he could not access without the consent of INEC. Under further cross-examination, he admitted that the information in the website Whistleblowers Data Analysis Facts Don't Lie website, www.factsdon'tlieng.com, could have been doctored. Under further cross-examination by the line senior counsel for the third respondent, PW59 said, as an expert, it is possible to use scientific method to decrypt data source and tamper or alter the content or information contained therein. PW59's report and evidence is thus hanging on the third-party information from an undisclosed source. The evidence of PW59 is no doubt caught by Section 37 of the Evidence Act, which provides, and I quote, hearsay means a statement, oral or written made otherwise than by a witness in the proceedings, or B, contained or recorded in a book or a document or any record whatever, proof of which is not admissible under any provision of this Act, which is tendered in evidence for the purpose of proving the truth of the matter stated therein. I underline some portions. End of quote. As can be seen from the evidence of PW59, you cannot, by any stretch of imagination, be classified as an expert opinion, as it is not supported by any direct knowledge of what his report contained. It is with regard contained, and it is not supported by anything he did directly with regard to the existence or otherwise of an INEC server, which he now claimed to have gotten the information from. He relied on the third-party information drawn or prepared or given to him or through the whistleblower, an anonymous source, an incredible and unverifiable source, which is not derived from his own personal knowledge. Worse still, his informant, the author of the content of the website relied upon by him, cannot be identified. Even if he could be identified, it is the alleged whistleblower or the anonymous author who claimed to be INEC staff or who was a former INEC staff that could give evidence of anything relating to the existence of the alleged server, from which he got the information, which he now put up in the website www.factsdon'tlieng.com, on which the petitioners heavily relied as containing results of the election electronically submitted via the smart card reader. PW59's evidence is very unreliable because it is hearsay and it is inadmissible. In Saraki and Neferan, Federal Republic of Nigeria, a case decided in 2018, Weze, JSC, said, now, it is well known, hearsay evidence, oral or documentary, is inadmissible and lacks probative value. Section 37 and 38 of the Evidence Act 2011, Ozude and Inspector General of Police, 1965, 1 All Nigeria Law Reports, 102, Okoro and the State, 1998, LPELR 2493 SC 17, 1998 14 NWLR Part 584 at page 181, Buhari and Obasanjo 2005 13 Nigeria Wiki Law Report Part 941 at page 1, particularly at page 317, DOMA and INEC 2012 All Federation Weekly Law Report Part 628 at pages 813, particularly at page 829, 2012 13 NWLR Part 1317 at page 297, Okpara and Federal Republic of Nigeria 1977 NSCC 166, Management Enterprises and Otusonya 1987 NSCC 577, 1987 2 NWLR Part 55 179, Ojuku and Oidiwe 1984 1 SCNLR 247, end of quote. I also made reference to some other cases in respect of the position. PW 59 also went out of his way to interpret INEC's manual in providing the INEC manual providing for electronic transmission of results of the 2019 general election. They said the witness is not competent to interpret election manuals which were admitted and tendered and admitted in this court as an exhibit. It is within the province and domain of this court to give interpretation to the election manuals and regulation of INEC, which I have done above. In effect, the evidence of PW3, PW4, PW16, PW17, PW36, and PW59, together with the expert report in XBP 91, cannot be relied upon to come to the conclusion that there was indeed, in fact, there was INEC server or servers, as the case may be, wherein results are transmitted electronically from the smart card readers in the 2019 presidential election. The pieces of evidence given by those witnesses lack the probative value to prove such an allegation. Now, the evidence of PW60. The petitioners have also relied and regarded the evidence of PW60 as the evidence of an expert to establish the anomalies or irregularities they pleaded in the core 11 forecast states earlier listed in this judgment, and constructed, in respect of which they constructed various tables to show the loss of the vote loss and vote gains by the petitioners and the second respondent, and came to the conclusion that if the errors committed by INEC officials are done away with, the petitioners will be leading by 222,332 votes. I think a proper appreciation of what the petitioners have done in the tables aforesaid, it will not be out of place to set out the submissions of facts by the learned senior counsel for the petitioners in the final address from paragraph 4.46 through to paragraph 5 to paragraph 4.52, which are as follows, and I set them out. This table, constructed in the learned senior counsel address, was lifted from the exhibit attached to the witness on oath of PW60. A calm perusal and examination of the exhibit attached, exhibit P K90 to A90 to 90AK, shows a conglomerate examination of the form EC8A from polling units with observation by him which polling units results were signed or not signed, which one shows bad votes or mutilated results, and sundry other criminal allegations of malpractices or irregularities. It is a strange attempt by the petitioners to use PW60 as a witness testifying in respect of all anomalies or evidence of crime allegedly committed at the polling units and doctrine of results by unnamed persons. No witnesses were called to establish all the allegations made against the results of the election in the polling units or the local government's level. Witness number 60, PW60, testified that he used duplicate copies, that the pink copies of Form EC8As to carry out his job, and he utilized from EC8As, EC8Bs, and EC8C series. Under cross-examination, however, he recoiled and stated that he, in fact, used certified copies of Form EC8As. He did not know what Form EC8C is. All the things he did in Exhibit P90 A to K ended up in what he called an executive summary on the findings on votes recorded in certified 2 copies of Form EC8As for the 11 focal states. He failed to demonstrate to this court how he came about the conclusion reached by him, and upon which the petitioner's learned senior counsel raised the table which I've set out above. It is my decision that PW60 cannot be regarded as an expert under any guise. As a matter of fact, he admitted under cross-examination that he was not certified by any institution. His evidence, like the evidence of PW59, lacks any probative value or worth, and the pieces of evidence he gave are not worthy of any weight to be accorded them in this petition. Consequently, I hold that the petitioners did not prove any of the complaints laid out in respect of the 11 focal states, just as they failed to prove the facts in paragraph 106 of the petition, result of which they claim was derived from votes in the server imputed through smart card readers. Again, the tables injected or constructed in the final address of the learned senior counsel for the petitioners are not covered by any of the pleadings of the petitioners contained in paragraphs 16 to 106 of the petition in relation to issue 3 under consideration. The law needs no restatement because it is now tried that parties are bound by their pleadings, and any evidence laid which is at variance with averments and pleadings of the parties go to no issue and will be discountenanced by the court. Made reference to a few cases on the position. It also follows that the brilliant address of the learned counsel cannot take the place of pleadings or evidence which ought to be led through witnesses conversant with the facts in issue. The aforesaid tables computing votes ascribed to the petitioners and the respondent, the second respondent, as representing correct votes by the parties cannot be countenanced because they lack any probative worth. The courts do not accord or allocate votes to parties in an election petition or on arbitrary evidence that has no support in pleadings and evidence adduced before it. I refer to a statement by His Lordship IT Muhammad JSC, now CJN, in the case of INEC, Silver and INEC, which I've set out before now, wherein he said, "It is clear from this piece of evidence that the appellants did not themselves know the number of votes alleged by them to have been cancelled by the first respondent. It is known to all that a court of law is not a magician who will begin to allocate votes or to reduce votes arbitrarily. It relies and makes its decision upon tested evidence placed before it. So the appellants have failed to lead evidence as to the actual number of votes alleged to be cancelled at the Bayelsa state government election held on 5th and 6th of December 2015 and on January 9th, 2016. Their claim as pleaded goes to no issue at all. And further, the case of Oti and Ekweazu Supra relied on by the appellant is not helpful to them, as it is quite distinguishable from the present appeal, end of quote. Another point, important point to recall, is that the relief sought in ground 15A is that it may be determined that the second respondent was not duly elected by a majority of lawful votes cast at the election. It has been acknowledged by the parties that it is a declaratory relief, and the law places heavy burden on the petitioners to prove the relief or their entitlement to it on the merit. The allegation contained in the paragraph contained imputation of crimes also in the electoral processes against the second respondents, against the first respondent and their officials/agents. Some of the allegations are as follows. 1. Inflation and deflation of votes. Alteration of figures and votes cast in favor of the petitioners. Overvoting. That the first respondent wrongly credited petitioners. That the first respondent wrongly and unlawfully credited the second respondent with votes which were not valid or lawful. Polling units. Wards, collation centers, and state collation centers. That the first respondent's official did not correctly collect votes from polling units in Abia, Adamawa, Akwa Ibom, Anambra, Bauchi, Bayelsa, Benue, Borno, Cross River, Delta, Ebonyi, Edo, Ikiti, Enugu, FCT Abuja, Gombe, Imo, Jigawa, Kaduna, Kebbi, Kogi, Kwara, Lagos, Nasarawa, Niger, Ogun, Osun, Ondo, Oyo, Plateau, Rivers, Sokoto, Taraba, Jobe, and Zamfara State. The petitioners did not call any witness in respect of all these sundry allegations made in respect of each of these states to give evidence of wrongdoings and/or/crimes allegedly committed in the presidential election conducted in the said state. Apart from the fact that the allegation must be proved beyond reasonable doubt because it is criminal in nature, it is also incumbent on the petitioners to call evidence polling unit by polling unit in order to establish all the accusations, irregularities, and gross misconduct alleged against INEC officials, the second and third respondent, and other persons. That is the requirement of the law. In Yesom and Peterside, Kekereku has stated that the purport of the appellant's submission in respect of the evaluation of evidence by the tribunal, which was affirmed by the lower court, is that the tribunal and the lower court applied the decision of this court in Kaki and PDP and Ucha and Elechi Supra. They would have reached a different conclusion. It is significant to note that there are 23 local government areas in Rivers State. According to PW 53, a state collation agent, there are 4,442 polling units and 1,350 voting points in the state, making a total of 5,000 voting points. Some allegations made by the first and second respondents include Roman 1, non-voting due to violence, thuggery, and intimidation of voters. 2, snatching of election materials, non-use of card readers. 3, non-collation of results at ward level at ward collation centers. 4, arbitrary collation of figures. Arbitrary allocation of figures. 5, non-provision of Form EC 8A. 6. Result sheets not showing results of all political parties that contested the election. 7. In order to prove the alleged acts of non-compliance, it is necessary for the petitioners to call witnesses from all the affected polling units to give first-hand testimony of what transpired. Out of the 56 witnesses called by the first and second respondent, 18 were ward coalition agents who received information from polling agents in their various units. Their evidence was not tied to any of the exhibit standards. Some of the witnesses, PW 19, 20, 24, and 35, who were local government coalition agents for the second respondent, gave sweeping testimony covering 4 local governments on non-use of card readers, hijacking of materials, illegal thumbprinting of ballot papers, etc. The polling agents from the affected wards were not called to testify. The tribunal made special reference with testimonies of these witnesses, and the evidence of PW 49 has been dealt with extensively earlier. I am inclined to agree with the learned senior counsel for the appellant that the evidence of PW 40 cannot take the place of polling agents or voters who were disenfranchised. Again, in the case of Gundiri and Nyako, decided in 2014, Ogumbi JSC, still on the significance of evidence of polling agents, had this to say: the significance of polling agents cannot therefore be underestimated in the case at hand, if the appellant must prove the facts, if the appellant must have the facts to prove their case. The best evidence of the appellants could have had was that the agents at the polling units who were physically on the ground and in true position to testify as to what transpired at the election. The consequence of shutting them out for whatever reason is very detrimental to the appellant's case. See the case of Hashidu and Goje, 2003, 15 NWLR, Part 843, 352, and Buhari and Obasanjo, 2005, All Federation Weekly Law Report, Part 273, page 1 at 164 to 165. 2005, 13 NWLR, Part 941 at page 1, particularly at page 4 to 48, paragraphs B, C, where a Jiwumi JSC said, among others, the evidence required to establish a crime must be evidence of a witness who saw or heard or took part in the transaction upon which was given evidence. It is written law that hearsay evidence is not admissible for the purpose of establishing a crime. See Section 77 of the Evidence Act, end of quote. On the fatal effect of failing to call a polling agent, the case at Agbala and Chime, 2009, 1 NWLR, Part 1122, 373, Act 433 to 434 is relevant, where it was held thus. None of the appellant's party agents that allegedly represented the appellant had signed or collected the results of the election form from the numerous polling booths and were called to testify in this petition. A fortiori, the failure of the appellant to call party agents that represented and served as representative at the various polling units to give evidence was fatal to the petition. I also made some reference to some other cases. Because there's no eyewitness account and no evidence was called by the petitioners to prove the scathing allegations of misconduct, electoral misconduct, which are in the nature of allegations of a crime, there's nothing that this court can base a decision in respect of such sundry allegations. What is more, The petitioners tendered all the Form EC8As, like I said, EC8Bs, EC8Cs, EC8E, and Form EC40G, and other relevant forms used by INEC for the recording of votes and declaration of the report of the result, the subject matter of the complaints in paragraph 16 to 106 of the petition. However, I have mentioned, and I will repeat it, that the petitioners failed to call the makers or their agents who were signatories to the documents and who did not sign or sign but are agents of the petitioner to testify concerning the irregularities and allegations made against the respondent. The petitioners, in effect, dumped these exhibits on this court, dumped their exhibits on this all-important issue or unlawfulness of votes on the court without calling their makers or those with knowledge of the document to testify. This court cannot, therefore, in law, accord any probative value to the exhibits. It is the duty of the petitioners to tie their documents and exhibit to the aspect of their case and to lead their witnesses to demonstrate the application of the votes explained in their pleadings and the other evidence of alteration, inflation, or deflation of votes, raking up figures in favor of the parties by the electoral officers or other persons. In the case of Ekpazu and Oti, 2016, Galadima again said, it is settled law that a party who did not make a document is not competent to give evidence on it. I also refer to the case of Ladoja and Ajimobi, case of Emmanuel and Umana, which I also referred to earlier on. The learned senior counsel for the petitioners has submitted that they have established the position, that the established position in this and many other cases has changed, and that the party is no longer required to tie or link documents in evidence to specific areas of its case to the documents it relates. He cited and relied with some relish on the case of MTN and Corporate Communication Investment Limited, which was decided this year, and citation of which is set out. The case is also reported in 2019 6 Supreme Court Monthly at page 100 for the submission. However, the facts of the case the documentary and other pieces of evidence involved in the case are, however, distinguishable from the facts in this case. The facts in that case involve a contract between the parties, and the document in question was the written contract, which was admitted at the trial court as Exhibit A. Exhibit A was admittedly the binding agreement between the parties, and the appellant before the Supreme Court used it as the basis for the termination of the contract by issuing Exhibit B in the case. At the trial, the respondent's witness had given evidence on the terms of Exhibit A, and he was cross-examined by the appellant's counsel. On the arguments before it by the appellant's counsel that Exhibit A in the case was not demonstrated, Kekere Ekun, speaking for the Apex Court, JSC, stated earlier that it is therefore not correct to contend that the terms of Exhibit A were not demonstrated before the court. The salient point to be noted in this case is that Exhibit A in question was an agreement between the parties, the terms of which were not in dispute, but expressly admitted by them. On the contrary, the contents of the documents tendered by the petitioners from the bar are and have been frontally, directly, and specifically disputed in the pleadings of the parties, such that proof, as required by law, becomes absolutely necessary if the documents were to be used and relied on in the determination of the petition. The allegations in respect of which the documents were put in evidence as contained in the paragraphs of the petition are varied, they are distinct, they are different and diverse in context, in character and nature, for each of them to require specific link or connection to the evidence of the witnesses who testified in respect thereof. The facts and circumstances of the case of MTN and Corporate Communication Investment Limited Supra are therefore clearly different for it to be an opposite authority that would avail the petitioners here. This position as it is my view that the MTN's case did not change the position of the Apex Court in the case cited earlier on the law that a party who tendered documents or documentary evidence in support of his case has a duty to link, to connect, and demonstrate the specific aspect of his case in respect of which the documents were tendered, if the court was to accord any probative value to them in evaluation of evidence. The case is therefore unhelpful to the petitioners on the point. I am conscious and aware of the submissions of the Land Senior Counsel for the petitioners that this court should hold that the first and third respondents have abandoned their pleadings because they did not call any witness to testify on their behalf. The tried position of the law is that a defendant to an action or a respondent in an election petition is entitled to rest his case on that of the claimant or petitioner, where he has, through cross-examination, elicited or extracted sufficient evidence to support and prove the facts or assertions contained in his pleading. In the circumstance, a defendant or a respondent to a petition can decide not to call any witness. That, however, does not amount or constitute not calling evidence or failure to call evidence. This is the position of the law restated by the Apex Court in case of Andrew and INEC, decided last year by Kekerekum JSC. Her Lordship stated thus: with regard to the contention that the court below was wrong to affirm the finding of the tribunal that the first respondent did not abandon his pleadings by failure to call evidence in support thereof, I hold the considered view that both the lower courts were correct in their finding. Having tendered documents and evidence, albeit from the bar, and having thoroughly cross-examined and discredited the appellants, it could not be said that the first respondent had abandoned his pleadings. In Akomalafe and Guardian Price Limited, 2010, 3 NWLR, Part 1181, page 338 at 351, F to H, and 353 to 354, H to B, this court held evidence elicited from a party or his witness under cross-examination, which goes to support the case of the party cross-examining, constitute evidence in support of the case or defense of the party. If at the end of the day, the party cross-examining does not call any witness, he can rely on the evidence elicited from cross-examination in establishing his case or defense. One may, however, say that the party called no witnesses in support of his case, but not evidence, as the evidence elicited from his opponent under cross-examination, which are in support of his case or defense, constitute his evidence in the case. The exception is that where the evidence so elicited under cross-examination must be on facts pleaded by the party concerned for it to be relevant to the determination of the question or issue in controversy between the parties, having regard with the fact that the relevant evidence elicited from the appellants relate to the facts pleaded by way of defense to the action, they form part of the respondent's case and can be relied upon by the respondent in establishing their case to the action without calling witnesses to further establish the said defense, end of quote. I also made reference to some other cases, citations of which are set out. I agree with the submissions of the Learned Senior Counsel for the first and the third respondent to the effect that they have elicited sufficient evidence under cross-examination of the petitioner's witnesses in support of the first and third respondents' averment as contained in the pleadings in defense of the issue under consideration. The fact still remains that the petitioners, as I found before, have not discharged the onus on them of establishing that the second respondent was not elected by a majority of lawful votes cast at the election. The evidence of all the 62 witnesses called by the petitioners is not sufficient to prove the monumental allegations of electoral malpractices pleaded in paragraph 16 to 106 of the petition. PW62, who is the star witness for the petitioner, admitted under cross-examination that he was not at any of the polling units, ward collation centers, local government collation centers, even state collation centers, to witness the voting, collation, and computation of the votes scored by the parties in the election. PW2 was in the petitioner's situation room in Abuja during voting exercise and announcement of results at the polling units and at all other stages of the election throughout election day and up to when election results were announced. He admitted that under cross-examination, that collation and declaration of the presidential election were done manually in his presence in Abuja and was present when the chairman of the first respondent announced the presidential election, even though he did not sign the result. On the existence of INEC server, this witness stated that he has never seen it and he did not know its particulars. All he said is that INEC kept assuring them that electronic voting would take place, but its evidence under cross-examination, no such thing happened or took place. All the pieces of evidence given under cross-examination by PW62 were for the benefit of the respondent. I agree with the submission of the learned state to the respondent that the petitioners have not proved that the second respondent was not duly elected by a majority of lawful votes cast at the election. In the result, issue 3 is hereby resolved against the petitioners. Issues 4 and 5 were treated together. Now, after a consideration of the submissions by the Learned Senior Counsel for the parties, I resolved issues 4 and 5 as follows. The relevant paragraphs of the petition in respect of the allegation of corrupt practices can be found in paragraph 364 to 387 of the petition, while the portion pertaining to allegation of non-compliance with all the provisions of the Electoral Act as amended are also in the said paragraphs. The elements of corrupt practices given are as follows in the said paragraphs. A, compromise printing/production of election materials. B, manipulations/misuse of staff resources. C, manipulation of ballots and ballot boxes. D, manipulation of card readers. E, manipulation of accreditation and collation. F, manipulation of security agencies and militarization of election. G, manipulation of election material delivery. H, arbitrary arrest, detention of petitioners, members, and supporters. I, massive thumb printing of ballot papers. Particulars of non-compliance, which are set out in the paragraphs I mentioned, on issue of non-compliance with the provisions of the Electoral Act are as follows. 1, non-holding of election and cancellation of results. 2, wrong and deliberate entry of wrong results. 3, non-accreditation. 4, non-authentication of results by presiding officers. 5, overvoting. 6, inflation and deflation of votes. 7, wrong entries in Forms EC8As. All these were said to have affected the 11 focus states of Borno, Yobe, Bauchi, Gombe, Jigawa, Kaduna, Kano, Katsina, Kebbi, Niger, and Zamfara states. Pursuant to the provisions of Section 135(1) of the Evidence Act and the settled position of the law, the petitioners have a duty to prove all these allegations, which are of a criminal nature, beyond reasonable doubt, and by witnesses who can give an eye account of all the allegations because they are criminal in nature. In Emmanuel Umana, which I've cited earlier, Weze JCA said, in one word, the lower court, relying on the opinion in the newspaper article, purported to abrogate Section 135(1) of the Evidence Act 2011 by judicial fiat. That section provides that, and I quote, if the commission of a crime by a party to any proceedings is directly in issue in any proceedings, civil or criminal, it must be proved beyond reasonable doubt. In my humble view, it is difficult to see how the lower court could have legitimately wished away the position of this court, which, interpreting the above section, had maintained that a petitioner who makes allegation of a crime, of commission of a crime, as the basis of challenging the election of a candidate who was returned, must prove the allegation beyond reasonable doubt. See Buhari and Obasanjo, 2005 SCNJ 147, 2005-13 NWLR, Part 941-1, Nwobodo and Ono, 1984 1 SCNLR, page 1 at 28. Now, as pointed out above, the allegations of violence, voter intimidation, hijacking, and snatching of electoral materials, kidnapping, and others in paragraphs 27, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 54, 61, Roman 1 to 4, 61, 10, Roman 10, 61, 11, 72, Roman 2, 26 to 43, 76, 78, 70, 78, 82, 83, 88, and particularly paragraph 15.1 of the first and the second respondent petition are criminal in nature and ought to be proved beyond reasonable doubt. I also refer to some other cases on the proof required, the standard of proof required in order to prove allegations of a criminal nature. The position of the law is thus settled that a petitioner who alleges non-compliance with the provision of the Electoral Act in the conduct of an election or in the electoral process, particularly in the polling units where election took place, has the onerous duty of calling eyewitnesses polling unit by polling unit to give evidence of the non-compliance. It is also opposite to say that the position of the law today, as settled by this court and the Apex Court, is that where the allegation of non-compliance with the provisions of the Electoral Act and allegation of corrupt practices are made and coupled with allegations of commissions of crimes in electoral processes, eyewitness accounts must be called, and the allegations will have to be proved beyond reasonable doubt. How have the petitioners fared in the quest to overturn the election on the two allegations under issue 4 and 5? Now, under ground 2 of the petition dealing with non-compliance with the provision of the Electoral Act as amended, the petitioners pleaded in so many paragraphs of the petition that the agents of the petitioners were stationed at polling units in all the focal 11 states, and that they connived, that the respondents, officials of the first respondent, connived with the members of the security agents, namely members of the armed forces, in intimidating, chasing away supporters of the petitioners and members of the PDP, that this connived in stuffing ballot boxes with ballot papers, that they connived in assisting the members of the APC and supporters of the second respondent to carry out multiple voting, that the army and the police connived with the respondent to carry out massive rigging in stronghold of the petitioners, that the election was marred in Bauchi State by irregularities, violence, harassment, intimidation of the petitioner's agents by policemen and military men aided by the respondent, and there was unlawful cancellation of votes. They also alleged that no real voting or election took place in Dekina local government of Kogi State, as heavily armed thugs, fake policemen, sponsored by the third respondent, invaded several polling units. They also alleged that the Nigerian army were used by the respondents in Zamfara State to chase away PDP supporters, and that other criminal acts were committed by them. They also said that in Nasarawa State, out of the 1,496 polling units, the first respondent returned nil accreditation in 68 polling units. It is also the allegation that the second respondent manipulated and used security agencies to influence the outcome of the election in his favor by retaining General Tukur Yusuf Buratai, Chief of Army Staff, Admiral Ibok Ikwe Ibas, Chief of Naval Staff, and Air Marshal Sadiq Abubakar, Chief of Naval Staff, and Air Marshal Sadiq Abubakar, Chief of Air Staff, with a view to using them to intimidate supporters of the opposition to prevent them from voting. It is also the petitioner's allegation that in Rivers State, in Oyo State, in Kaduna State, notable members of the PDP were detained and arrested. It is their further allegation that in Rivers State, in Borno State, in Benue, Kogi, Yobe, Kebbi, Kaduna, Zamfara, Nasarawa, Plateau, and practically all the states of the Federation, military and police officers actively formed themselves as supporters of the respondent to attack, terrorize, and scare away the second petitioner's supporters and to prevent them from voting. The petitioners did not stop there. They also allege, by the said paragraphs under consideration under issue 4 and 5, that soldiers invaded several local governments in Rivers State to disrupt election. They also said that there was massive thumb printing of ballot papers by the agents of the second and third respondent in connivance with the first respondent. They also allege that prominent members of the PDP were detained in those 11 states which they consider focal states by security agencies at the instance and promptings of the second and third respondent. All the above inventory of criminal allegations, as pleaded and alleged by the petitioners in the pleading, were not and are not established before this court, as none of the party agents or polling agents of the petitioners were called to prove the various allegations made against the respondent and members of the Nigerian Army and the police force. The only polling agents called are PW5 for Unit 008 Zamfara State, Nagogo Guram in Jigawa, PW6 for Unit 001, the Farm Duse in Guaram, in Jigawa State, 3, PW12, Unit 009, Tankokoba in Nasarawa State, 4, 5, PW46 at Unit 009, Sharp Corner, Karu in Nasarawa State, and PW49 for 001, Baroa Kwanga in Nasarawa State. All the other witnesses who gave evidence, that is PW14, 15, 39, 43, 48, 50, 51, 52, 56, 57, 58, and PW 13, 14, and 15 are all ward coalition agents from Niger, Nasarawa, Yobe, Borno, Kogi, who virtually testified of the information passed to them by the polling agents. Those who testified as local government coalition agents gave evidence as to what was reported to them or what the information they received from agents from their wards. Those who testified as state coalition agents in this petition for Niger, PW7, PW8 for Katsina, PW23 for Borno State, and PW61 from Kogi State. Though some of the ward coalition agents said they visited some of the polling units under them, where there were criminal complaints of violence and anomalies, but none of them said they covered all the polling units, and none of them stayed at any particular polling unit throughout the duration of the election. Apart from the 2 or 3 who said they did not vote, all the said witnesses voted and were duly accredited by their own account. However, apart from the 5 witnesses from the polling units, the other witnesses, as is shown, gave what is clearly hearsay evidence of what allegedly took place at the polling units. They are pieces of evidence either alone or taken together with any other piece of evidence, do not and are incapable of proving all the specific allegations of facts pleaded in grounds 2 and 3 of the petition, and all the criminal allegations contained in paragraph 227, 231, 232, 234, 236, 250, 293, 299, 302, 306, 308, and 309, 310, 317, 322, 328, 329, 333, 335, 373, 380, and 381 of the petition, which are not proved. Those witnesses are also not in a position to prove or establish any of the allegations under issues 4 and 5, they not being eyewitnesses as alleged of the acts of violence or criminal acts and commissions of crime alleged as having taken place at the polling units. The polling units agents who could have testified to the horrendous allegations of crimes were not called. I made reference to some cases in respect of proof of allegations made in respect of polling units. And I continued that the petitioners did not call any of the persons detained or arrested by security agents as the alleged agents of the second and third respondent to give evidence of their arrest or detention or harassment, except that Buba Galadima, PW1, who gave the evidence that he was before and after the election harassed or invited by security agents. This evidence has nothing to do with all the allegations of violent criminal acts stated in the above paragraphs of the petition. All the paragraphs of the petition pleading allegations of misconduct by the army or the police are not established. There is no admissible evidence on record to support them. It is also noteworthy of what that none of the witnesses was shown from EC8As, EC8Bs, and EC8C to identify them in relation to the polling units, wards, local government, state, or centers they operated on the day of election. And no documents through them were tendered except from the bar, exhibit PW40, exhibit P40, and P62. It is also here pertinent to refer to paragraphs 277, 319, 326, 334, 336, 338, 349, 350, 352, and 358, 368, 369, 370, 371, 372, and 383 of the petition, which is falling under ground 2 and 3, and issues 4 and 4, issues 4 and 5, where certain individuals were accused of various electoral offenses, acts of thuggery, and compromise. Like I mentioned, there is no admissible evidence from any of the witnesses to link any or all of the individuals mentioned therein with the allegation of corrupt practices and non-compliance with the Electoral Act. The allegations against the said individuals were not established. Whatever evidence led, there is none that tantamounts, whatever evidence is led, is tantamount to hearsay evidence, as none of the witnesses actually witnessed any of the facts pleaded in the paragraphs of the petition. What is more, none of the personalities accused, including the security agencies, are parties to the proceeding, and this court would be acting in violation of the rights, as we have already decided in the ruling which I read earlier this morning, in contravention of Section 36(1) of the Constitution as amended, to adjudge them guilty of all the allegations against them in their absence. It must be stated that serious and criminal acts of electoral offenses and other criminal acts, irregularities, anomalies, rigging, etc., as laid out on the onset of the treatment of these issues, were made against the respondent and those perceived to be their agents on duty on the day of election. In the spectrum, like I mentioned before, of criminal law, allegations against agents cannot be held against their masters without any evidence directly linking the masters with the allegations against their agents. I'm not unmindful of the strong submission of the learned senior counsel for the petitioners, who stated that the evidence of PW 62 actually proved and established grounds 2 and 3 of the petition, that their evidence was not challenged under cross-examination. In the petitioner's final address, in reply to the first respondent's final address, in paragraph 5.02, 0.03, 5.17, and 5.18 thereof, the learned senior counsel said thus, and I quoted him: PW 61 is a coalition agent of the petitioners in Kogi State. In Kogi State, he is one Captain Joe Agada, retired. Under cross-examination, he said that he voted in a polling unit at Olaboro, Unit 18, that in some cases, disturbances started before election. He also visited 4 polling units on the day of election, and there are 2,300 polling units in his state. He visited only 4 polling units where violence, he said, was perpetrated. This was under cross-examination by the learned senior counsel for the first respondent. When he was further cross-examining, he said, he further said, among other things, that he was duly accredited before he voted and that the card reader was used for his accreditation. He did not have the Form 40G. He did not have the Form 48 to evidence the recording of any violence. He did not sign, and he did not sign the form, and he refused to collect the result after the election. He did not have the voters register in respect of the places complained of about the complaints in respect of the state which he represented the petitioners. They have dealt with the evidence of PW 60, whose evidence is also hearsay, in respect of the copies of the Forms EC8Cs, EC8Bs, and EC8C deployed in 11 states, in respect of which he was engaged to examine. The evidence of PW 62, the star witnesses, once again, covers virtually all the facts pleaded in the petition. Under cross-examination by all the learned counsel for the respondent, he left no one in doubt that he had no personal knowledge of all that happened at the various polling units across the country, whereas the petitioners based their allegation in paragraphs 107 to 387 of the petition. I've mentioned it. He stated that he was at the situation room of the PDP on election day, and the information contained in his witness statement on oath about wrongdoings at polling units, ward levels, local government level, state level across Nigeria were gathered from third parties who were their agents in the said level of the coalition of the election process. He was therefore not an eyewitness to any incident except the one that happened at the National Coalition Center, where he was the national coalition agent for the petitioners. He told the court that the coalition was done all over the country, including the national level, manually. PW 62's evidence cannot in the least at all command any value on the quantum of pieces of evidence given by him, and do not establish the horrendous allegations on commission of crimes and criminal allegations contained in the paragraphs of the petition. He cannot be in the situation room in his party's office and be at the polling units in all the polling stations or polling units and voting points in Nigeria. The petitioners under ground 2 of the petition, dealing with non-compliance with the provisions of the Electoral Act as amended, pleaded in the paragraphs of the petition which I've mentioned that there was overvoting in so many polling units. For example, in paragraph 1153, the petitioners avert thus, and I quote, overvoting. The petitioners shall contend that out of 1,941 polling units in the affected 26 local government areas in the state, the first respondent in respect of the 490 polling unit reflected results showing that the number of votes returned exceeds the number of accredited voters. The petitioners shall rely on this on the report of statistician. They also pleaded that many voters on the voter register in the 11 focal states were disenfranchised on various allegations of violence, manipulation, and compromise. The law is now settled that the only way to prove overvoting, inflation, or deflation of votes at the polling units, manipulation of voters' register by INEC officials, as pleaded by the petitioners, can only be proved and by a petitioner by tendering voters' register and the forms EC8As and all other relevant forms used in the election to enable the petitioners show that if the figures of scores representing overvoting is removed from the declared result, the petitioner would win the election. The petitioners in this case have not done so. They tendered no voters register. No. And the only forms they tendered from EC8As, ABs, EC8Cs, and EC8As were not utilized or demonstrated before this court by any of the 62 witnesses called by them. There is no doubt that this is detrimental to the petitioner's case. The petitioners have also made an allusion to the fact that the first and second respondent rested their defense on the evidence given by the petitioners and submitted that they are deemed to have abandoned their pleadings and admitted the petitioner's case. I have dealt with this issue in the course of this judgment and found that it cannot be said that the first and second respondent abandoned, the first and third respondent abandoned their pleadings or that they have conceded to the petitioner's case. No facts and evidence on record has shown that the petitioners have discharged the initial burden of proof cast on them by law under Section 131 to 136 of the Evidence Act 2011 and the Electoral Act and regulations and guidelines made thereunder in respect of any of the grounds upon which the petition is premised. It is true, as borne out by the record, that the evidence elicited under cross-examination of the petitioner's witnesses by the first and third respondent established their defense to the petition. The evidence elicited on facts and issues joined on the petition and replies of the parties go to support the pleadings in their defense. It is also pertinent to deal with the submissions of the respondents of the respondent that the petitioners merely dumped the documents tendered before the court on these particular issues without relating them to any aspect of their case, and as such, the court cannot deem them to have proved their case. The court cannot help the petitioners to do their job. The learned senior counsel to the petitioners argued to the contrary and contended that having tendered the documents from the bar, they become evidence. I have long dealt with this, and the law is now firmly settled that when documents are tendered from the bar or by a person who is not the maker, the court cannot accord such documents any probative value unless the makers are called to testify on the documents and answer questions in cross-examination on them. This is the position of the law. The respondents are therefore right in their submission that the petitioners dumped all the Forms EC8C series and other documents on this court. None of them was utilized by any of the witnesses who testified on behalf of the petitioners in order to demonstrate the specific areas, particularly that relate to issue 2, issue 4 and 5 in paragraph 107 to 387. All the experts, like I said in the earlier portion of this judgment, which were not demonstrated or linked to specific areas that relate to issues 4 and 5 of this petition, remain dormant and of no probative value to the petitioners. In the final result, for reasons set out in this judgment, I have come to the conclusion, which is inevitable and unavoidable, that the petitioners, on the basis of the evidence adduced before this court, have not proved any of the grounds contained in paragraph 15 of the petition as required by law. Failure by the petitioners to satisfactorily discharge the burden or onus of proof placed on them by law, this petition is liable to be and is hereby dismissed in its entirety. Before I end this judgment, let me also place it on record, and I would like to commend the Learned Senior Counsel for the parties for their industry and the brilliant final addresses on the issues conversed in this petition, which were very helpful to the court in the determination of this petition. We appreciate the cooperation of all the Learned Senior Counsel and other counsel who appeared before us in this petition throughout the conduct of the proceedings before the court. Parties in the petition shall bear their respective cost of prosecuting this petition. My learned brother to my immediate right will pronounce his decision in respect of this petition.
I took part in the conference linked to the judgment. I agree entirely with what has just been read.
My learned brother to my immediate left will pronounce his decision in respect of this petition.
I agree with the robust judgment pronounced by my learned brother, Mohammed Lawa Garba, JCA, with the addition of these few words by way of emphasis. Paragraph 15D and E of the petition aver that I quote, D, the second respondent was at the time of the election not qualified to contest the said election. E, the second respondent submitted to the first respondent an affidavit containing false information of a fundamental nature in aid of his qualification for the said election, end quote. Section 138, subsection 1A and E of the Electoral Act 2010 as amended by the Electoral Amendment Act number 25 for 2015 states thus, I quote, an election may be questioned on any of the following grounds. That is to say, A, that the person whose election is questioned was, at the time of the election, not qualified to contest the election. E, that the person whose election is questioned had submitted to the Commission affidavit containing false information of a fundamental nature in aid of his qualification for the election, end quote. The RW2, Mr. Suleiman Issa Mayadua, who was 77 years old at the time of his testimony on 30th of July 2019, swore that he was one of the classmates of the second respondent at the Katsina Provincial Secondary School, now Government College Katsina, between 1956 and 1961, where English language was the medium of communication, and that they wrote their examination in 1961 upon reaching class 6 in the state secondary school. The evidence of the RW2 was not discredited under cross-examination. A witness of 77 years old, such as RW2, is indeed an old man who, in virtue of advanced age, will lay on the side of truth. See in Wawuba against Enemo, 1988, 2N WLR Part 78, page 581 at 595, where the Supreme Court heard per the judgment prepared by Namekagu, JSC, as he was now of blessed memory thus, I quote, "It is a matter of common knowledge that old men often find it difficult to trace the truth," end quote. Accordingly, I accept the uncontradicted evidence of RW2 to the effect that the second respondent was indeed one of his classmates at Katsina Provincial Secondary School, now Government College Katsina, between 1956 and 1961, where they sat for their final examination upon completion of class 6. Educational qualification for election to the office of President of Nigeria is stated in Section 131, subsection D of the 1999 Constitution as altered. Thus, I quote, "A person shall be qualified for election to the office of President if D, he has been educated up to at least school certificate level or is equivalent," end quote. The educational threshold of, quote, "school certificate or is equivalent," end quote, in Section 131D of the 1999 Constitution as altered is interpreted in Section 318, sub 1A and B thereof in these ways, I quote, "School certificate or is equivalent means inter alia at least A secondary school certificate or is equivalent, or grade 2 teacher certificate, certificate, or B, education up to secondary school certificate level," end quote. The court, that is this court, the Court of Appeal, Koram, Obadina, Sanusi, Ogboagu, JJCF, had cause to interpret a similar provision in Section 106 of the 1999 Constitution, relying on Section 318, 1A and B thereof in the case of Digai and another against Nanchang and others. Citations supplied per Obadina, JCA, thus, I quote, "What is required under the law is that there must be evidence that a candidate is educated up to the school certificate level, and not that he must produce a certificate to that effect," end quote. There's also the case of Bayo against Njida, citation supplied, where it was heard by Ogboagu JCA, thus, as I quote, "As regards a secondary school certificate level, one does not have to pass the secondary school certificate examination. It is enough, in my view, that one attended a secondary school and read up to the secondary school certificate level, that is, without passing and obtaining the certificate," end quote. There is again the case of Chukwu against Chionwo, citation supply, where his lordship Akas, JCA, now JSC, while interpreting Section 99 of one of the local government bracket basic constitutional and traditional provisions, and bracket decree number 36 of 1998, which is similar to Section 318 of the 1999 Constitution supra, on the phrase, quote, "school certificate or its equivalent," end quote, heard thus, I quote, "It is not absolutely necessary that such a person must possess a certificate to enable him function effectively," end quote. Generally, there is a rebuttable presumption of literacy. A person is presumed literate until the contrary is proved by the person doubting or challenging that person's literacy. See the cases of Anaiza against Anyaso, then Otituju against Governor of Ondo State, then Jubosu against Obadina, then Ezeagua against Awudu, then Sunday against FRN, all citations applied. No scintilla of evidence was brought by the petitioner to rebut the presumption of literacy in favor of the second respondent that he attended education at least up to secondary school level in 1961 as stated on oath by the RW2. The second respondent therefore possessed the minimum educational qualification under Section 131D of the 1999 Constitution, read with Section 318 sub 1B thereof, to contest the said presidential election. The information given on oath by the second respondent to the first respondent, that is INEC, is P1 Form CF001 on its educational qualification reads, quote, schools attended / educational qualification with dates, attach evidence of all educational qualifications. Yes, and that's my one school primary qualification, primary school certificate, year 1952, 2 secondary, that is WASC 1961, then 3 higher, then officer cadet 1963. The affidavit accompanying the information is the P1 Form CF001 on educational qualification sworn to by the second respondent reads, I quote, that I am, number one, that I am the above named person and deponent on this affidavit herein. 2, that all my academic qualifications as filled in my presidential form, President APC/001/2015, are currently with the Secretary Military Board as at the time of this affidavit. 3, this affidavit is made in good faith and for record purpose, end quote. The information given by the second respondent to the first respondent in Exhibit P1 Form CF001 was on the submission of his primary school and secondary school certificates to the military at the time of his enlistment in the Nigerian Army in 1963. Giving false information and affidavit that amounts to lying on oath, it is a criminal offense under Section 156 of the Penal Code, which provides thus, I quote, whoever being legally bound by an oath or by any express provision of law to state the truth, or being bound by law to make a declaration upon any subject, makes any statement verbally or otherwise which is false in a material particular and which he either knows or believes to be false or does not believe to be true, is said to give false evidence, end quote. The next stage is on the proof or the allegation that the information by the second respondent to INEC in P1 Form CF001 on educational certificates is false. This is a criminal allegation which is directly in issue in the election petition, which must be proved beyond reasonable doubt or with lesser-like precision by the petitioners who had asserted in the petition that the information on the educational qualification of the second respondent given on oath by the second respondent to the first respondent is P1, that is Form CF001 is false, with the Section 135 of the Evidence Act 2011, that evidence which provides thus is part of the judgment taken as read. See also the cases of Mohammed against Wamako and others, citation supplied, Ipiaz against OT, citation supplied, Saleh against Abba, citation supplied, Mehaja against Gaidam, citation supplied. It is tried that he who asserts has the burden to prove the assertion or allegation. And if the allegation or assertion is criminal in nature, it must be proved beyond reasonable doubt by the person asserting it. See the case of Zakala against Dosan and another, citation supplied, pre-release judgment prepared by his lordship, ECHO JSC, to the effect that proof beyond reasonable doubt is not established by mere assertion. Furthermore, the Supreme Court, while considering similar issue inter alia of false declaration in the case of Mehaja against Gaidam, citation supplied, heard the lead judgment prepared by his lordship, Bagay, JSC, now His Royal Highness, the Emir of Lafayette, inter alia that, I quote, the necessary question is what must a party prove to succeed on the allegation of false declaration? The nature of evidence required in this kind of situation is similar to that of mathematical precision, or 2 multiplied by 2 equals 4. 2 times 2 is equal to 4, end quote. See also the guy against Nanchang Supra at 64, where the court held that, I quote, as I had indicated earlier in this judgment, this issue revolves on the two other issues already treated by me, but in specific hinges on the complaint of an alleged giving false information to the third respondent by the first respondent. Firstly, giving of false information either to the police and in this instant case to the third respondent certainly amounts to an allegation of committal of a crime. Again, the standard of proof is beyond reasonable doubt. See Section 138 of 1 of the Evidence Act, end quote. The quantum of proof beyond reasonable doubt will therefore be proved with mathematical precision, as stated by the Supreme Court in Mehaja against Gaidam, Supra. The petitioner sought to prove the allegation of false information by relying on Exhibit P24, a copy of the Vanguard newspaper of 21st of January 2015, where it was reported in part that the late judgment captured it, so I will not repeat it, but it's my judgment too. The petitioners further relied on Exhibit P25, a Vanguard newspaper of 1st November 2018, where similar information as contained in Exhibit P24 was quoted by one Ikechukwu Amechi, who described himself as the MD/editor-in-chief, the niche on Sunday newspaper Ikeja, Lagos, in their bid to establish the allegation. The petitioners again relied on Exhibit P80 video clip purporting to carry the same information as Exhibit P24, where the Director of Army Public Relations, the same Brigadier General Olajide Laleye, gave a press briefing on the said issue contained in Exhibit P24 in pursuit of the allegation. Proof beyond reasonable doubt of criminal allegation in question required the evidence of the military secretary or secretary military board who is in custody of the service records personal file or the second respondent and or by tendering evidence a certified true copy of the service records personal file or the second respondent as secondary evidence, or perforce by tendering evidence the original service records personal file of the second respondent through its custodian as primary evidence of what it contains. In other words, any document in the custody of a public servant, such as service records personal file or second respondents kept by the military secretary or secretary military board, should be proved by tendering evidence a certified true copy of the service records personal file or the second respondents in accordance with the provisions of sections 102B, 104, and 106 of the Evidence Act as secondary evidence of what the service records personal file or second respondent contains, or by tendering evidence the original file itself through the custodian thereof as primary evidence of what the service records personal file or the second respondent contains. In addition, the video clip Exhibit P80 is a piece of documentary evidence under sections 83 and 258 of the Evidence Act and required it to be tendered evidence through the maker of the statement or recorder of the interview or message who has personal knowledge of the matters dealt with by the statement or in performance of a duty to record information supplied to him by a person who had or might reasonably be supposed to have personal knowledge of those matters. None of the conditions in the proviso to Section 83 of the Evidence Act were met in this case. I highlighted the proviso there, and it's part of the judgment taken as read. So Exhibit P80 has no probative value. See Madueke against Okorafor and others, citation supplied. The Supreme Court also heard in the case of Adegbite against the state, citation supplied, but the late judgment prepared by His Lordship, Galumje JSC, that I quote, the lower court was also right when it refused to accord probative value to the newspaper report and radio interview, as newspaper report is not always the truth of the contents, end quote. Exhibits P24, P25, and P80 therefore lack probative value. The RW1 Major General Tarfa retired. One of the military corpsmates or the second respondent gave evidence under cross-examination by the first respondent that educational certificates were not submitted to the Nigerian Army during their enlistment to the Nigerian Army in 1963. The evidence of a witness, such as the oral evidence of RW1, who is not the custodian of the state service records, prisoner file, or the second respondent, would not suffice as proof of the criminal allegation beyond reasonable doubt or with mathematical precision. The comment under Section 156 of the Penal Code reads, I quote, comment, Pakistan Penal Code Section 191, Sudan Penal Code Section 167. 1. This section defines the giving of false evidence, known as perjury in English law. Part of the quotation is still taken as read. It is my modest opinion that once the alleged false statement is made on oath, as in an affidavit, its quality of being made on oath will bring it within the meaning of perjury, and thus under the ambit of the underlying comment number 1, supra. Because the legal consequence of lying on oath in an affidavit is a crime of perjury, proof of it requires corroboration under Section 202 of the Evidence Act. Corroboration being an issue of evidence exclusively for the legislative powers of the National Assembly, pursuant to Item 23 in the exclusive legislative list contained in the second schedule to the Constitution of the Federal Republic of Nigeria, 1999, as altered. Such statement on oath, that is affidavit, if alleged to be false, would require corroborative evidence in proof of it as provided under Section 202 of the Evidence Act. Proof beyond reasonable doubt would have, at the risk of repetition, entailed the testimony of the custodian of the service records, personal file, or the second respondent with the Nigerian Army, and or evidence of certified true copy of the said service records to establish the allegation of giving false information by the second respondent, the first respondent in Form CF001 Exhibit P1. See, by analogy, the case of Muhammad against Womako Supra, especially at page 592 thereof, with the judgment prepared by His Lordship, Kekere Kunjesi, while considering a case of alleged forgery or educational certificate and giving false information to the effect that proof beyond reasonable doubt or the allegations would require evidence, be it documentary or by communication, from the organization or authority concerned disputing the information. The petitioner did not list such evidence to prove the said allegation with certainty or mathematical precision. This would have amounted to prove beyond reasonable doubt or prove with mathematical precision or the allegation whether the second respondent submitted his primary school certificate and his West African school certificate to the military secretary or secretary military board or the Nigerian Army upon his enlistment into the Nigerian Army as an officer cadet in 1963, and would have corroborated the evidence of RW1 as required by Section 202 of the Evidence Act. Accordingly, even if the evidence of RW1 has some weight, the said evidence contradicting affidavit evidence on which the allegation of false information is predicated should have been corroborated by trustworthy evidence, as circumstances were not proved to corroborate the said admission made by RW1 under cross-examination. I conclude that the said allegation of giving false information by the second respondent to the first respondent as P1 from CF001 was not established beyond reasonable doubt. Bribery is an electoral offense under Section 124 of the Electoral Act. It is a corrupt practice within the definition of the phrase rendered by the Supreme Court in the case of Yusuf against Obasanjo, citation supplied per the judgment prepared by His Lordship Acholono JSC as follows, I quote, the term corrupt practices denote or can be said to connote and embrace certain perfidious and debauched activities which are really felonious in character, being redolent in their depravity and want of ethics. They become hallmark of a decayed nature lacking in conscience and principles, end quote. The PW28 testified of vote buying in that local government area of Bauchi State, while PW30 testified of vote buying in Zaki local government area of Bauchi State. Also, the PW32 testified of vote buying in Ningi local government area of Bauchi State. The PW29 testified of vote buying in Biliri local government area of Gombe State, while the PT2 testified of bribery of ANIC collection official in Agaragu/Tofa ward in Lafia local government area of Nasarawa State. The witnesses, Supra, did not mention the names of any of the voters whom they saw bribed. The court, this court, comprising Ete, Uwais, and Ademola JJC, heard in the case of Alega against Edun, 1978, NN, LRs, page 17 and page 26, that the names of the voters whom the witness saw bribed must be given in evidence before allegation of bribery would be heard to have been proved beyond reasonable doubt. The Supreme Court also heard in the case of Wazira and another against Gedan and others, citation supplied, following the case of Nyako against Balewa, citation supplied, and Alege against Edun, Supra, that allegation of bribery or corruption must be proved by the accuser beyond reasonable doubt by evidence identifying by name the voters that were bribed. Subsection 1A and B of Section 124 of the Electoral Act also require that the alleged bribe be given or offered to a voter. Therefore, it becomes necessary that the name of any of the voters whom the witness saw bribed must be given in evidence. This is to ensure that the corrupt practice of bribery was actually effected on a registered voter or voters not at large for the purpose of illicitly swaying the voters' free choice of candidate in the election in order to maintain a sanitized electoral process that will be seen to be conducted in a free and fair manner and or on level playing ground. There is no convincing evidence that the alleged bribe givers acted with the knowledge and consent of the second to third respondents or with the knowledge and consent of a person that acted under the general or special authority of the second to third respondents with reference to the election as required by Section 124, Subsection 6 of the Electoral Act, which, for emphasis, states that a candidate will only be held responsible for bribery or if the offense was committed with his knowledge and consent or the knowledge and consent of a person who is acting under the general or special authority of the candidate with reference to the election. Clear and unequivocal proof of allegation of bribery was also not made out by the petitioners, as it is not sufficient to suggest that the mere fact that somebody else bribed other persons to vote for a particular candidate was enough and conclusive evidence against a candidate in an election, as such a candidate cannot be held responsible for what other people did in the form of unsolicited aid of which he or his acknowledged agents were ignorant. See Anazodo against Audu, citation supplied. There was therefore lack of concrete evidence to establish that the second and third respondents personally committed a corrupt act of bribery or aided, abetted, or counseled, or procured the commission of the alleged corrupt practice of bribery. Nor was it established that the alleged act of bribery was committed through an agent that was expressly authorized to act in that capacity, or granted the general or special authority to act in that capacity on behalf of the second and third respondents. Nor did the petitioners establish that the alleged corrupt practice of bribery substantially affected the outcome of the election to warrant nullification of the election of the second respondent, whether Section 139, Subsection 1 of the Electoral Act, and the cases of Auda against INEC, Buhari against Obasanjo, Abubakar against Yaradua, Oke against Mimiko, Akeredolu against Mimiko, Ngige against INEC, all citation supplied. The PW59, the Kenyan witness, admitted he obtained the information contained in his P87, P88, P89 from a whistleblower's website which had hacked, permit the colloquialism, the website of the first respondent. The bottom line is that the information and data upon which the PW59 based its analysis of the results of the election contained in exhibits P87, P88, and P89 were sourced from the website of the first respondent, a public body, by means of hacking its website by a whistleblower. The website of the first respondent is doubtless a document within the meaning of Section 258, Subsection 1 of the Evidence Act, which defines document as any device by means of which information is recorded, stored, or retrievable, including computer output, end quote. Proceeding on the footing that the ultimate source of the information and data contained in exhibits P87, P88, P89 were illegally obtained from the website of the first respondent. The computer printout of the information and data in P87, P88, and P89 should have been certified by the first respondent, a public body in custody of a public document, as secondary evidence under Section 102, 104, and 105 of the Evidence Act as amended. Exhibit P87, P88, and P89 were not certified, therefore they have no evidential value. See Kobo and another against Dixon, certificate supplied. Per the lead judgment prepared by His Lordship Onogan, JSC, later CJ, and thus, I quote, the fact that the exhibits are computer printouts or e-documents does not change their nature and character as public documents. His Lordship Ogumbi JSC had this to say in his judgment, I quote, also on the same footing is the document exhibit L, which is a computer or internet-generated document allegedly printed by the appellants from the website of the third respondent. As rightly submitted on behalf of the respondents by virtue of Section 102, Roman 2 of the Evidence Act, such document is classified as public document and only a certified true copy of same is admissible in evidence. It follows, therefore, that the two exhibits D and L share the same fate and are rendered of no legal effect. The lower court was therefore on sound footing in upholding the tribunal's stand by expunging these documents. The following authorities are relevant in support: NIPC Limited against Thompson Organization Limited, Kankia against Megemu, and then Owunia against Omotosho, all contained in the quotation. Besides, the PW59 admitted that information or data upon which the expert evidence is in course, his base was hacked by a whistleblower from the website of first respondent, from whose website the witness derived the information and data that formed the basis of his analysis, contained in exhibits P87, P88, and P89. Sections 14 and 15 of the Evidence Act as amended state, quote, evidence obtained A, improperly or in contravention of law, or B, in consequence of an impropriety or of a contravention of law, shall be admissible unless the court is of the opinion that the desirability of admitting the evidence is outweighed by the undesirability of admitting evidence that has been obtained in the manner in which the evidence was obtained. 15. For the purpose of Section 14, the matters that the court shall take into account include A, the probative value of the evidence, the importance of the evidence in the proceeding, that is B. C, the nature of the relevant offense, cause of action or defense, and the nature of the subject matter of the proceedings. D, the gravity of the impropriety or contravention, and E, whether the impropriety or contravention was deliberate or reckless. F, whether any proceeding, whether in bracket, whether or not in a court, end bracket, has been or is likely to be taken in relation to the impropriety or contravention. And then G, the difficulty, if any, of obtaining the evidence without impropriety or contravention of law, end quote. The website of the first respondent from which the information that was hacked, being any device by means of which information is recorded, stored, or retrievable as a computer tool, is a document under Section 258, subsection 1 of the Evidence Act, which should have been accessible to the petitioners for inspection for the purpose of filing and maintaining the election petition under Section 151 of the Electoral Act, empowering the court to order for inspection of electoral documents and or any other documents in the custody of the first respondent. See Ladoja against Ajimobi, citation supplied. Consequently, the petitioner had no basis to subtract the law by benefiting from the hacked website of the first respondent through the machination of the whistleblower, thus resorting to self-help, which the Supreme Court deprecated in the case of Governor of Lagos State against Ojukwu, citation supplied. The law also frowns at a party benefiting from a wrongful act. Further, in the case of Toti and Okpabi against Okpabi, citation supplied, Niagolo GSC expressed reservation on placing weight on evidence obtained by felonious means or by breaking the law, as in this case. The criminal case of Sadao against the state following pre-counsel case of Kruma, son of Kani, against the Queen on the propriety or illegally obtained evidence by way of illegal search of an accused person has to be appreciated against the background that criminal law is addressed to all and sundry and is for the protection of society in the pursuit of which the state and the citizenry are stakeholders. Therefore, incriminating relevant evidence found on an accused person by illegal means will meet the ends of justice on ground of overriding public interest for the protection of society by the state using the illegally obtained evidence to prosecute the accused, whose remedy may lie in a civil action for damages against the state for the illegal search. In the present case, the petitioners deliberately and recklessly relied on the hacked information and data in question when it would have been convenient for the petitioners to have followed due process under Section 151 of the Electoral Act to inspect the document and obtain certified true copies thereof. At the time, the first respondent's website was hacked before the petition was filed, thus breaching Section 15 of D, E, and G of the Evidence Act. Based on the discussion supra, I respectfully place no weight on exhibits P87, P88, and P89 as they are a product of unjustifiable and illegally obtained evidence by means of hacking the website of the first respondent by the whistleblower using his website, through whom the PW59 improperly obtained the information and data contained in exhibits P87, P88, and P89. The PW60, the statistician is not competent to analyze and produce report or editing results and alleged malpractices afflicting them, though presented as an expert witness. His evidence on documentary analysis of the electoral documents contained in P98 to P90J, therefore, have no evidential value. See Ladoja against Ajumobi, Supra at pages 142 to 144. I quote Ogumbi JSC there. I'm quoting, PW1's report or inspection is replete with analysis of election materials, and at the end of each table, he gave analysis and opinion and conclusion of the materials analyzed by him. This is evidence at pages 4397 and 4398 of volume 5 of record reproduced earlier in the course of this judgment. The analysis of the smart card reader accreditation, PVC, collected and votes cast on each table in each local government is made from pages 3611 through 4371 of the volume 5 of the record. The witness, PW1, is also not qualified to analyze or subject to forensic scrutiny electoral forms, results, and documents in the manner he did. In the case of Buhari against INEC, statistics supplied on a somewhat related matter, the Court of Appeal, without much ado, rejected the appellant's report because he was not qualified to analyze INEC documents. The lower court, at pages 386 to 389 of the report, wasted no time in rejecting the documents. Also, in the recent decision in AC 409/2012, our shared Congress against Rear Admiral Murutala H. Nyako and others delivered on November 12, 2012, reported in 2012, APELR 19649 SC or 2015, 18 NWLR Part 1491, then page 352. This court, in a similar situation, rejected the evidence qua statistical analysis of a witness who described himself in his statement on oath as a graduate of economics, a consumer banking officer, and a retail financial analyst, and head thus. They're quoting the PW66 by qualification and learning is not an expert in the art of establishing multiple registration and voting elections, special skill in respect of which would have been entitled him to assist the tribunal to form his opinion on the point, end quote. See also the case of NPP against Osman, citation supplied, where the judgment prepared by His Lordship Aboki, JCL. The RW Force attention was drawn under cross-examination by the petitioner's learned senior counsel to the first name, quote, Mohammed, end quote, on Exhibit R19, the Cambridge Assessment International Education Certifying Statement, while the first name of the second respondent in the petition is, quote, Muhammadu, end quote. There should be no fuss over the name Mohammed and Muhammadu because, as held by the court, that is Quran Msofo, Ikongbe, Onogen, Mikaelu, Nwuta, JJCA in Alliance for Democracy against Fayoshe, the citation supplied per the lead judgment prepared by and so forth, JCA thus, I quote, and I ask this, what really is in a name or a name? Cuculus non facit monachum. Now, name derived from Latin nomen nominis in its noun form, see Chambers 20th Century Dictionary, page 875, is defined to mean, quote, that by which a person or a thing is known and called a designation, end quote. Of the big quote continues. Of what concern or to whom does it matter if it chooses to be called or known by many names or very many names? I confess that I know or no legislation or a decree in Nigeria restricting the persons to a number of names he may be called or known by no such law, end quote. It is therefore not in doubt that the document exhibit R19 bearing the name Muhammad Buhari refers to one and the same Muhammad Buhari, the second respondent in the petition. In the result, I too concur that the petition has not been proved as required by law and deserves to be dismissed, and hereby dismiss it and abide by the consequential orders contained in the judgment pronounced by my learned brother, Garba JCA.
My learned brother to my extreme right will now pronounce his own decision in respect of this petition.
Well, I agree with the conclusion contained in the legal judgment as per the fate of this petition. The facts are well spelled out therein, and I do not intend to repeat them. However, I deem it expedient to further address the issue of whether or not there existed a server for use by the first respondent, as well as the relevance of smart card readers during the 2019 general elections. The petitioner's stance is that by their utterances, news briefings, and the manual, as well as guidelines for the conduct of election, it is not in doubt that the first respondent intended to and did make use of smart card readers and the server for the electronic transmission of election results during the 2019 presidential and National Assembly elections. The law is straight that he who asserts must prove such assertion. See Section 1361 of the Evidence Act 2011. See also Awuse and Odili, Mogaji and Odofin, Elias and Omodare, Daudu and NMPC, with citation inclusive. In Adigije and Nwogu, this court by Ogumiju JCA held that, and I quote, Section 137 of the Evidence Act 2004 provides that for a burden of proof in civil cases, the burden of first proving the existence or non-existence of a fact lies on the party against whom the judgment of the court will be given if no evidence were produced on either side, regard being had to any presumption that may arise in the pleadings. If such party adduces evidence which might reasonably satisfy a court that the fact sought to be proved is established, the burden lies on the party against whom judgment will be given if no more evidence were adduced, and so on successively until all the issues in the pleadings have been dealt with, unquote. See also M.O. Kanu and Sons against Nzeribe with citation per Abaji, JCA, then now JSC. The quotation is here, but I do not intend to, it's taken as having been read. The petitioners herein have pleaded in paragraphs 26 to 29 of their petitions as follows, and they said they are quite extensive, but I will take them as having been read. The first respondent in response averred in paragraph 15 and 16 of the first respondent's reply to the petition as follows. I also detail the averments of the first respondents in my own contribution. In the light of the above set out environments, there is no doubt that issues were strongly joined on the existence or non-existence of a central server, and whether the results of the presidential election, which held on the 23rd of February 2019, was electronically transmitted. The petitioners in support of their pleading in this regard called PW2, PW3, 4, 12, 16, 17, and 36. The evidence are inclusive here. PW2 testified that he was an ad hoc staff of the first respondent, and he worked as registration area technician RATEC and ward collation officer for Ward 5, Constituency 2 of Ogbaegbe Mandoni local government area of Rivers State. He stated that before the election day, he was trained by the first respondent, INEC, on the use of the smart card reader at the election. The smart card reader was to be used at each polling unit for the mandatory accreditation, verification, authentication, collation, and transmission of results of the election, and that apart from one polling unit in the ward, where there was a snag, the smart card was used in all the other polling units for accreditation, verification, authentication, and collation of results of the election. He, however, admitted under cross-examination that he did not function as a presiding officer or assistant presiding officer. PW3 also was an ad hoc staff of the first respondent, who testified that he was employed as a presiding officer, PO, at the Civic Center Amoji polling unit with code 005 in Amoji ward in Enugu East local government area of Enugu State. He added that he was trained by the first respondent on the mandatory use of smart card readers for authentication, collation, and transmission of results of the election at the polling units, and that upon conclusion of voting and collation of results, he transmitted the results of the polling units electronically to the first respondent server using the code or password provided by the first respondent and as directed. He, however, stated under the cross-examination that he was not told the name or number of the server, but all he knows is that he transmitted the results to a server. PW also gave similar evidence on the use of smart card reader at the election, as he deposed in his statement on oath that he electronically transmitted the results of the election into the server belonging to the first respondent using the code or password as provided. He agreed also during the examination that he did not state the number of the smart card or server location in his statement on oath. PW12 testified also that he was a polling agent for the petitioners in Tanko Kutawan polling unit of Chanchaga local government area of Niger State. He stated that in his polling units, election commenced with the use of smart card readers, which later broke down and resort was had to manual authentication of voters on the directive of the presiding officer. PW16 also testified that he was an ad hoc staff of the first respondent and worked as assistant presiding officer, APO, for Wako polling unit 001 in Kwali, local government area of the Federal Capital Territory. He stated that the election was conducted by a smart card reader, and the result of the election was transmitted electronically to the first respondent server using the code also provided by first respondent after verification by the respondent's area technician. He also stated under cross-examination that though he transmitted result to the servers, but the server number was not given to him. PW17 equally in his statement of oath deposed that he was the first respondent ad hoc staff during the election at an APO. He was engaged as an APO at the local LEA primary school, Galadima/Gwarimpa polling unit, FCT, where the card reader was used for accreditation, verification, authentication, collation, and transmission of votes through the first respondent server by the code provided by first respondent. He also stated during cross-examination that he was told during training that the server belonged to the first respondent, though he was not given the server number. Lastly, PW36 testified as evidence also that he was an ad hoc staff of the first respondent during the election, and he functioned as area presiding officer, APO1, where he used the smart card reader in his polling unit and equally transmitted the election results electronically to the first respondent server via the smart card reader. His response during such a cross-examination was that he was trained to transmit results to INEC, and although he did not personally see the server, he was told about it by the first respondent. On the other hand, the first respondent did not call any witness to support their pleadings in this regard, but rather opted to rely on the petitioner's case via the evidence elicited during cross-examination. The second and third respondents also did not call any evidence to support or deny the existence of the first respondent server, which is very clear. Though I'm not so mindful of the tri-state of the law that a party can rely or rest its defense on the evidence given by a claimant during cross-examination, but this is premised on the condition that such evidence must relate or derive from the facts averred to in the pleadings. The bottom line here is that neither the first respondent specifically nor the second and third respondents called any evidence to add life or flesh to the facts in denial as averred in their pleadings with regard to the use or non-use of the smart card reader or server. The law is long settled that where issues are joined on any averments, but no evidence is laid to support such, the end result is that such averments are deemed abandoned and prone to be struck out. See Omoboreo and Ajasin, Magnuson and Koiki, Cameroon line and O22 is with citation inclusive, also Odunsi and Bambala, and Amechi and INEC. On this premise, the position of the law is succinctly stated by the Supreme Court, per Aloma Mukhtar JSC, letter CJN, now retired, in the case of New Breed Organization Limited against Eremosele, 2006, 5 Nigeria Weekly Law Report, part 974, at page 499, as follows. Quote, when a defendant refuses to adduce evidence in his defense and rests his case on the evidence of the plaintiff, then he has himself to blame if the trial court finds for the plaintiff based on his evidence as was done in the instant case. The position of the law is that where an adversary fails to adduce evidence to put on the other side of the imaginary scale of justice, a minimum evidence adduced by the other side will suffice to prove its case. See Braimo and Bangboshe and Nwabuoku and Otis with citation, unquote. In the instant case, the respondents, as particularly the first respondent, refused or neglected to adduce evidence on the vexed issue of whether or not smart card readers were used during the 2019 elections, or that there exists a central server, but opts to rest their case on the evidence as adduced by the petitioners. The consequence is that there is no other evidence to put on the other side of the imaginary scale to judicially weigh the evidence on both sides of the divide. It follows, therefore, that the evidence as adduced by the petitioners in support of their pleadings, as earlier detailed, will be taken as sufficient proof that smart card readers were used during the presidential election, which held on the 23rd of February 2019. What is more, Section 15.2 of the Electoral Act 2010, as amended in 2015, states as follows. 15.2, I quote, voting at an election under this Act shall be in accordance with the procedure determined by the Independent National Electoral Commission, unquote. Pursuant to the above provisions, the first respondent introduced Exhibit P27, that's regulations and guidelines for the conduct of elections, and Exhibit P28, Manual for Election Official 2019, also Exhibit P33. The sex exhibit contains rules and regulations to guide the first respondents officials in the conduct of the elections, and this includes the use of smart card readers to verify permanent voters' card and authenticate same before voting, as shown in paragraph 8B of Exhibit P27. Other relevant paragraphs are 10, 13, 28, and 29. The same goes with chapters 1, 2, and 3 of Exhibit P28, which contains specific procedures to be adhered to before, during, and after close of voting, as well as transmission of results and accreditation data using the smart card readers. That said, I am, however, not oblivious of the present state of the law as enunciated by the Supreme Court in Yesomwike against Peace Aside, 2016-7 Nigeria Weekly Law Report, Part 15-12-452, or 2016 LPLR 40,036 Supreme Court, wherein Kekere Kun JSC stated as follows, and I quote, I had stated earlier in this judgment that INEC is to be commended for the innovation of the card reader machine to bolster the transparency and accuracy of the accreditation process and to maintain the democratic norm of one man, one vote by preventing multi-voting by a voter. Nonetheless, Section 49(1) and 2 of the Electoral Act 2010 as amended, which provide for manual accreditation of voters, is extant and remain a vital part of our electoral law. The section provides thus, any person intending to vote with his voter's card shall present himself to a presiding officer at the unit in the constituency in which his name is registered with his voter's card. 2. The presiding officer shall, on being satisfied that the name of the person is on the register of voters, issue him a ballot paper and indicate on the register that the person has voted. In the recent decision of this court in Shinkafi and Yari Supra, Okoro GSC stated thus, my understanding of the function of the card reader machine is to authenticate the owner of a voter's card and to prevent multi-voting by a voter. I am not aware that the card reader machine has replaced the voter's registrar or has taken the place of statement of result in appropriate forms. Again, where the JSC, Nokereke and Umahi and others, unreported Supreme Court 1004/2015, delivered on the 5th February 2016, reiterated the position as follows, quote, indeed, since the guidelines and manual, Supra, which authorize the use and deployment of the electronic card reader machine were made in exercise of the powers conferred by the Electoral Act, the said card reader cannot logically depose or dethrone the voters' registrar whose juridical roots are firmly embedded or entrenched in the self-same Electoral Acts from which it, bracket, voters' registrar, directly derives its sustenance and currency. Thus, any attempt to invest it, that's the card reader machine procedure, with such overreaching preeminence or superiority over the voters' registrar is like converting an auxiliary procedure into the dominant procedure or proof that is proof of accreditation, unquote. That's per Kekereku. See also the case of Emmanuel Udom and Umana, number 1, 2016-12 Nigeria Weekly Law Report, part 1526-179. The quotation is there, is quoted part of the judgment there. Also, their Lordship Roseviver JSC also addressed the issue at page 86 and 87 of the same report. And in INEC and Peter side, Mohammed JCN as it then was also stated, and I quote, however, in the present case, the first and second respondent petitioners only relied on the second leg of paragraph B of section 138(1) of the Electoral Act 2010 as amended to claim that the election in Rivers State was invalid only for failure of the officials of the appellant to comply with the appellant's order on them to use smart card readers for accreditation of voters for the election, which the respondent petitioners failed to relate to any provisions of the Electoral Act to qualify as non-compliance with the provisions of the Act. In this regard, I am of the view that the first and second respondents / petitioners failed to prove their case at the election tribunal, that the failure to use smart card readers for accreditation of voters at the election had the effect of nullifying the entire election in Rivers State, unquote. Okoro JSC also made its own contribution, and the same with Sanusi JSC, the portion of which are reproduced in this contribution. I also refer to the case of Shinkafi and against Yari, 2016 LPLR 26050, Supreme Court. decision, where the Supreme Court stated that the function of smart card reader is solely to authenticate the owner of the voter's card and to prevent multi-voting by a voter, and cannot replace the voter's register or statement of results in appropriate forms. See also Ogboru and Okowa, 2016-11 Nigeria Weekly Law Report, part 15, 22, 84, at 129 per Okoro JSC. And I set down the quotation, the portion of the judgment here. In the light of the above set out decisions, which represents the extant law vis-a-vis smart card readers as a means of proving non-voting, overvoting, transmission or non-transmission of election results, the issue of smart card readers in the present discourse serves only the purpose of helping to improve the accreditation process during election, and as such complements the procedure set out in Section 49 of the Electoral Act 2010 as amended, which provisions, I dare say, does not include recourse to a central server for the purpose of collation or declaration of election results. This point finds expression in Section 63, 65, 69, and 74 of the Electoral Act 2010 as amended. Section 63 provides, said, the presiding officer shall, after counting the votes at the polling unit, enter the votes scored by each candidate in a form to be prescribed by the Commission as the case may be. 2, the form shall be signed and stamped by the presiding officer and countersigned by the candidates or their polling agents where available at the polling unit. 3, the presiding officer shall give to the polling agents and the police officer where available a copy each of the completed forms after it has been duly signed as provided in subsection 2 of this section. And 4, the presiding officer shall count and announce the result at the polling units. Then Section 65 said, after the recording of the result of the election, the presiding officer shall announce the result and deliver same and the election materials under security to such persons as may be prescribed by the Commission. Then 69 said, I quote, in an election to the office of the President or Governor, whether or not contested in any election to any other elective office, the result shall be ascertained by counting the votes cast for each candidate, and subject to the provisions of Section 133, 134, and 179 of the Constitution, the candidate that received the highest number of votes shall be declared elected by the appropriate returning officer. Then Section 74 concludes. He said, every result form completed at the ward, local government, state, and national levels in accordance with the provisions of these acts or any guidelines issued by the Commission shall be stamped, signed, and countersigned by the relevant officers and polling agents at those levels, and copies given to the police officers and the polling agents where available. The resultant effect of the above set out provisions is that collation of results are to be done manually, and declaration of such results are to flow from the figures as entered in the relevant forms at the various levels of collation. It is not dependent on the content or use of a smart card reader for the transmission of election results. Hence, Section 74 specifically provided that every result form completed at the polling units, ward, local government, and states and national level shall be stamped, signed, and countersigned by the relevant officers and polling agents at those levels, and copies given to the police officers and polling agents where available. Albeit, and for the purpose of posterity, the first respondents serve the interests of the generation now and generation next. I will emphasize again that to all intents and purposes, the law requires or mandates the first respondent to operate a website under Section 71 of the Electoral Act, which provides as follows, and I quote, the Commission shall cause to be posted on its notice board and website a notice showing the candidates at the election and their scores, and the person declared as elected or returned at the election, unquote. The above set out provisions use the word shall, which connotes mandatoriness or command. See Shetima and Goni, and Oba and Suswam, as well as Onochie and Odogun with citations. Furthermore, the posting of the results must be on the notice board and website. The word "and" is conjunctive, which means that the result must not only be posted on the notice board, but also on the website. A website is defined by the English Dictionary Online Edition as, quote, a computer connected to the internet that maintains a series of web pages on the World Wide Web, unquote. It also defines a server as a digital computer that provides workstations on a network with controlled access to shared resources, unquote. In the light of the above clarifications, it will not be out of place to emphasize that as a fact, duly proved as earlier indicated, and by law, as per the Electoral Act 2010 as amended, there exists a website managed and controlled by the first respondent. The above clarification, however, notwithstanding, I also hold that the petitioners did not adduce sufficient evidence to justify the grant of the relief sought. Thus, the petition is also hereby dismissed, and I abide by the consequential orders made in the late judgment, including the order as to costs.
My learned brother to my extreme left would now pronounce his own decision in respect of this petition.
I completely agree with the comprehensive and incisive judgment delivered by my presiding justice, M.L. Gabra, PJCA, as it contains enough details to show that in all respects, the petitioners have failed to establish or prove any of the relief sought by them, either in the main or in the alternative.
Gentlemen, we have noticed several errors that are contained in the judgment which I delivered. We shall undertake corrections of the judgment and then give parties copies, clean copies after the corrections.
My Lords,
yes, Dr. Udoku.
My Lords, may I start by commending your Lordships for the industry exhibited in the rulings and judgments delivered today, lasting, by my calculation, for a little over 8 hours. I sincerely believe that this must be the longest sitting of any court in this country and the longest judgment in the annals of jurisprudence and judicialism in this country. My Lords, let me also thank my Lords for the opportunity given to us to present our case, and also commend my Lords that the petition at least was not allowed to expire, because that is very, very important to us as petitioners, and we are grateful.
You're welcome.
My Lords, having said this, my Lord, the presiding justice had already promised that in the shortest possible time, we will get the rulings and judgments.
Yes, you will.
in the next 24 hours.
We shall get the corrections made soonest, as soon as possible.
As court pleases.
It's even better in our own interest to get finished with these judgments so that we can all go back to our respective divisions.
As court pleases. Once again, I thank my lords.
We shall do that.
Thank you, my lords.
You're welcome.
My lords, my lords, as we have always shown, we are neutral. But my lords, sincerely, we must thank your lordships for two things. This is one of the rare occasions we have where everybody, including my boss, Livy, are given too much latitude to do anything we can do here legally. My lords, we must be very grateful to all of you, my lords. My lords, we are grateful. The second thing, sir, my lords, we want your lordships to pray to us so that this analytical mind will come to, not me again, no, we are finished, to the little ones, because the way these things have been analyzed, my lords, some of us are happy that we are not on the bench. I can't do it. Honestly, I cannot do it. Lastly, my lords, we are so grateful that it is a unanimous judgment. And for INEC in particular, my lord, we are happy that all my lords say, INEC, you are right not to have transmitted results electronically. My lords, we are grateful.
All right. Electronic transmission of results.
My lord, on behalf of the second respondent and also our leader, Chief Olanik Pekon, who is unavoidably absent on account of being out of jurisdiction, we would like to thank my lords for very, very detailed, painstaking, insightful, and also refreshing rulings and judgments. My lord, there are lots to be taken away. Having regards to the volume of the judgment and rulings, it is not unexpected that there will be errors. But I want to confirm that the errors we are talking about are just typographical errors and not anything substantial. Maybe for the benefit of all concerned, that they are typographical errors and not anything substantial that has to do with the substance of the judgment. I take it that way because once your lordship has delivered judgment, your lordship are functious officials.
Yes.
Except to correct typographical errors.
Let me just say
Yes, sir.
that it is common knowledge
Yes, sir.
that when we say we observe errors
Yes, sir.
in the delivery of judgment,
Yes, sir.
not errors in the substance of the issues decided, but of course typing errors. And these are what we want to now correct. We can't correct ourselves. After delivering a judgment, we cannot correct ourselves. We cannot correct our errors on law, on the facts. That will be for...
My lord, will find that very comforting. Above all, my lord, like I said, we want to thank my lord for these judgments. A few things to take away in terms of thanking my lord for confirming the identity of Livinus, that Livy and Livinus are the same. And for being consistent to confirm that Mohammed and Muhammad are the same. My Lord, that's being consistent. So we thank my Lord for that. Also, we thank my Lord for letting us know that there is need to tower above sentiments, that cases are decided based on proved facts and evidence and devoid of pre-judgment whatever. My Lord, we thank my Lord for everything. All we can say is that, my Lord, may God just continue to refresh and energize you. Because it's been about almost 8 hours almost 9 hours. All of them taken together. Everybody has been able to sit down and look at the whole thing, and I know that it has taken a lot of hours also to prepare. And all we can say that from on this side is to say thank you and thank you and thank you for being on the side of justice without fear or favor. And we are grateful, sir.
You're welcome. Oh, please, we say something to
Please, your lordships, ingratitude, they say, is the mother of all evils. I join my colleagues in thanking your lordships. But before I do that, my lord, not because you are not the most important, but because I need to say this, that I thank my learned friends for the petitioners. I've always insisted that we should give leadership to other members of the public whenever we feel aggrieved, instead of taking to cordial and guns. To do that. My Lord, I thank your lordships, and I say that in this sacred well of your court, it is this day that your lordships are carrying out a solemn constitutional duty. You have brought all the important petitions to conclusion by handing down a landmark unanimous decision just delivered. I just want to appreciate your lordships. You have had to produce in hearing and deciding this petition. That your lordships plowed on during the court vacation period, when the rest of your brethren were enjoying their well-deserved or well-earned rest, surely calls for commendation to your eminent selves. From the start, your lordship had to bear through needless, inappropriate insinuations from within and outside the courtroom that eventually led to the adjustment in your lordship's personnel that finally heard the case to the conclusion that just happened today. Aside all these, my lords, those who wouldn't give justice a chance to reveal its virtues and, in this case, resorted to assaults against its just resolution in a largely unrestrained social media, spewing disrespectful conjectures and unalliable commentaries that our homegrown legal and judicial philosophy had over time adjudged as undue interference with the administration of justice and therefore unacceptable. All I'm trying to say, my lord, is that it has truly been a night of long knives. But despite all these, your bearing all these indignities, your lordships with stoic fortitude labored through it, all the while breaking your back on several interlocutory proceedings and grueling drudgery of the trial that had all sorts grown into it. I must at this juncture congratulate your lordships on the telling fact that while at it, this court's decision on interlocutory matters, especially the one on the purported INEC server that were challenged in the Supreme Court, were resoundingly affirmed by the Lord. This particular fact, my lord, must be seen by all as a credit to the deep learning and experience that aggregate your lordship's judicial worth. Finally, my lord, it is a lesson to be learned from this litigation that the excellent work that your lordships have just accomplished, it is the court cases that should be transacted, won and lost in courtrooms and not on TV and social media. My lords, we also thank you. You are not owing us. Rather, we are the ones owing you. We thank you for commending, though, and they have been paying. Yes, my lords, the chairman of APC, when we went out, he said, I didn't know that judges are also surgeons. I said, yes, I am happy you are in court. My lords are surgeon. The surgical operation you did was very methodical. I can continue on and on. It is well that this judgment is unanimous. It is well that all the stems, roots, and branches of the case have been refused. We have learned a lot. I wish you well, my lords. I can see that you are old young men, but when you grow old, I pray that, like the glory of sunset, your night will be peaceful. Thank you.
Young men. Well, gentlemen, on a final note, we also like to thank you for all the kind words and commendation from the court. But primarily, we take it as a primary constitutional and national responsibility that we have been called upon to undertake and make sacrifices in our own little way towards the development of this country. And we assure you that we are always ready to do so. And we look forward to meeting all of you at some other fora. Thank you very much. The court will now rise.
Court.
Come on, please.
I dash you one.
Welcome back to our studios. Of course, we'll be monitoring the presidential election petition judgment